Good afternoon and welcome to all of you in the virtual meeting room for Subject 1. Those who have just recently joined, my name is Han Kogels and I'm the Master of Ceremonies during this IFA virtual event for the coming days. We have now reached a time in which the Subject 1 will be dealt with, and without further ado, I would want to give not the floor, because we cannot invite somebody on the floor, we can invite somebody on the screen in a virtual event. So I would like now to give the screen to the chair of the panel of Subject 1, Lieselot Kana.
So let me just get started. You can actually ask questions during the session. If you have a question to a member first, so then we can identify to whom the question is asked. So before we start, I also wanted to thank all the contributors from the IFA branches that have made this volume 105A on reconstructing the treaty network really interesting, a very useful academic work. So, starting off, we are going to set the scene, and we're going to ask Carmel Peters, who is a revenue official from that amazing country that has more sheep per inhabitants than any other country, but also, surprisingly today, named the world's fattest parrot as the bird of the year. But perhaps that's not the important part. Carmel is also the first person to co-chair WP1 of the OECD and the UN Tax Committee. So please, Carmel, set the scene for us. Go ahead.
Thank you, Lisa. Kia ora koutou, greetings from New Zealand, which is otherwise known as the Long White Cloud, and has named the Kokoriki, the fattest parrot, best parrot and best bird in New Zealand. The subject that we're talking about today is on the reconstruction of the treaty network. But sometimes when you start with these types of discussions, you need to look a little bit back to see what the scene was. My first slide, I don't know, are we sharing the slides? No?
You're supposed to have it, yes.
Oh, well, okay. So in any event, I cast my mind back to 2012 and 2013, and during that time there was a lot of activity. There were Senate inquiries into large firms in the United States. There were inquiries into Apple, Microsoft, Caterpillar, to name a few. And if any of you are tax treaty historians or historians of tax events, there is a marvelous recording of the Apple inquiry that you can see, I believe, on CNBC, which was led by Senators Carl Levin and the late John McCain. You can listen to those, which are fascinating. There was also UK inquiries by a parliamentary committee led by Margaret Hodge, who was investigating HMRC over their taxation of Starbucks. There was also a lot of media focus on multinational taxation, and that led to public concerns building about fairness of tax systems. Ultimately, the G20 and the OECD came up expressing support for some kind of multilateral action. And in the meantime, governments were under pressure to act unilaterally, which took the form of a digital services tax. If I look back to my own experience during that time, I think we were a bit slow to see the to see how much public how much concern there was from the public and from politicians, because there had to date been so much stability in the two blueprints for OECD for tax treaties led by the OECD and the UN model. So it was a bit of a shock, and I know that as a public official myself, that I did not see it coming as quickly as I might have, and it was only until our closest neighbour, Australia, announced a crackdown on multinational tax avoidance that I actually, our firm was motivated to start telling politicians that there was something to look at, that there was an issue. In 2013, sorry, I think I've got that wrong, but in 2013, the finance ministers of the G20 expressed support for a plan of action, which ultimately culminated in the G20 OECD Action Plan. And I guess another important feature of the exercise was that the OECD opened its doors to non-members to participate in what was called the BEPS Inclusive Framework. Okay, next slide. A critical feature and I think a very innovative approach was to say that it was of the OECD approach was that in terms of having a multilateral instrument that we all signed up to, was that countries committing to BEPS had to meet what they called the minimum standard. And that had three changes to the treaty model and revised commentary that were quite profound. And only time will tell how profound they were, but my view is that they were profound. And I guess it would be, we should start with the first one, which was that there was a change to the title and to the preamble to the treaty to emphasize that that as well as aiming to relieve double taxation, it also the treaty aims to prevent opportunities for non-taxation or tax avoidance. So it was and a lot of people would say, well, that's just, nice words, but I think that going forward, the courts will look at that language and it will be quite important in terms of interpreting the rest of the treaty. So it's not motherhood and apple pie. It is a serious change to our treaty. So what was the minimum standard? And we should go to the next slide. So in addition to the new preamble that countries who were committed to BEPS had to sign up to.
Can't move them now. So we will have to ask Anya.
So in addition to the minimum standard, countries had to embrace a treaty anti-abuse rule, and there were three flavors to that treaty. The three ways in which you could meet that test. The first one was a principal purpose test, which we call the PPT alone, and that was certainly based to some extent on a provision that the UK had used. They called it the main purpose test in their in their treaties, particularly for Articles 10, 11 and 12, the passive income articles. The other way you could meet it was a principal purpose test, plus there was also prepared what they called the simplified limitation on benefits, which is an LOB. So based on the US model, but without all the bells and whistles. The LOB, the US LOB, is a mechanical provision that looks at, that seeks to look through a series of black letter tests as to whether a taxpayer is generally entitled to the benefits of a DTA. And the third option was to have the detailed LOB, to have treaties that had the detailed LOB provision plus anti-conduit rules. So these were the three ways in which you could meet the minimum standard on treaty anti-abuse rules. Next slide, if that's possible. And the third change was to do with disputes resolution through MAP. And there were two elements to this change. And we call them covered tax agreements in the context of the multilateral instrument, because those agreements were the ones that countries elected to have it covered by the multilateral instrument. And the first thing was that if you had a covered tax agreement that didn't have a MAP provision, one would be included. So that was the first element to it. And then the second element is, even if you did have a multilateral instrument that had a MAP provision, it would be amended to allow taxpayers to bring their dispute to either competent authority to the competent authority of either jurisdiction to resolve the certainty as to how the DTA would apply, the double tax agreement would apply, the bilateral treatment would apply. So that was the third element. Next slide, please. I'm going through these things rather quickly because they're all going to be covered in much more detail by the other speakers in the panel, but I thought I would just sort of set the scene, set the framework. Those were the what we called the minimum standard. If countries wanted to commit to the BEPS program, then they had to sign up for those three things. Over and above that, there were optional provisions to target specific treaty abuses. And I'm just going to run through these really quickly because they are going to be dealt with in more detail by my colleagues on the panel. The first one was in Article 1, a provision dealing with fiscally transparent entities. And the point of this provision was to address problems for countries and taxpayers where classification of entities was mismatched. So one country would see an entity as opaque and another country would see it as, through the lens of their domestic law, see it as transparent. And it was designed to ensure that the treaty applied appropriately either to allow treaty benefits or deny treaty benefits in those situations. There was also a saving clause, which has a long time been a feature of the US model, which was to articulate the principle that there was already understood, not that treaties would not prevent you from taxing your own residents under domestic law, with exceptions which are outlined in that provision. There was also a new provision in Article 4, which deals with residents, to require competent authority agreement for determining the residence of a dual resident entity. And that was considered quite critical to avoiding treaty abuse. The the third one that I would mention is that we looked at a dividend transfer holding period threshold in Article, sorry, that should be Article 10, not Article 12, my mistake. In any event, the idea was there to say that you had to hold the dividends for 365 days in order to benefit from the treaty rates at source. So in order to benefit from the treaty, you had to have shown that you'd held the dividends for a period of time, and that you weren't just holding them on the day that the dividend was being distributed. Similarly, there was a strengthening of the land-rich company rules in Article 13. And the idea there was to ensure that you didn't just, the rule being that you had to have more than, if you were selling shares in a land-rich company that held more than 50% of immovable property in the source state, that you didn't just look at the date of alienation, but that you actually went further and cast your eye back 12 months again to see that you had it for a period of time, and it wasn't a case of you just inflating the amount of structuring so that you inflated the amount of immovable property on the day of alienation. And finally, there is what we call the third state PE rule, and I look at this, and I know we'll go into it further, as a sort of anti-treaty shopping rule, whereby the resident state cannot, or the taxpayer in the resident state cannot take advantage of a treaty by establishing a PE in a third state whose income is attributable to a PE in the resident state. So they were these are optional provisions, so you don't have to do them. And some countries just did the minimum standard, and some countries did the optional provisions as well. And we will discuss why that was in the panel. Next slide, please. Finally, there were some optional provisions that were actually focused on PE abuse. Provisions were added to address the situation of splitting up of contracts to avoid time thresholds. So if you had a time threshold in your treaty, whereby you might have the rule of thumb of 6 months that's in the commentary, or you might have specific provisions which required you to undertake activity for a period of time, that you couldn't avoid that by just arranging for contracts to be split between members of a group. There were also provisions that were included to, so we've always had in our treaty a carve out from paragraph 1 of Article 5 for preparatory and auxiliary activities. Some of these are some of these are sort of outright. Well, there is, to be honest, it's a contentious issue, but most countries, many countries interpret those as absolute carve-outs for the activities that are listed in Article 5.4. But the ultimate decision was that they were outdated, and that we needed to subject all activities to a rule that they needed to be preparatory or auxiliary activities. So that's the sort of warehousing type activities. There were also provisions included to prevent splitting up of activities, to avoid the creation of a PE, or to avoid that the operation of the carve out for only preparatory and auxiliary activities. So those were the three main items for directed at PE abuse, and again they were optional, and again we will discuss why they were optional further on. I think I'm finished my slides.
Thank you, Carmel. Yes, thank you so much. We've set the scene now for why we're here today, about reconstructing the treaty network. And now we want to have a look into pre-BEPS responses to these BEPS concerns. And I will introduce now to you Professor David Duff from Canada, who is one of the general reporters as well. And he will take us through this part. We will also hear in this part comments from Phil West, a practitioner from the United States, and Mukesh Bhutani, who is a practitioner from India. So slide 10, please, and please go ahead, David.
Thank you, Lisa, and greetings from Vancouver, Canada, where the sun is just beginning to rise. I have my coffee though, so I'm well awake. Even more so now. Although the BEPS project introduces a number of significant changes to the tax treaty network reflected in the MLI and the 2017 revisions to the OECD model, of course, it didn't occur in a vacuum. And so one of the set of questions that we asked in the branch reports and is reflected in the general report is an understanding of where countries were at with respect to the BEPS concerns before the BEPS project. And as the report indicates, some of that background helps explain the responses of different countries to the MLI and how they have responded with respect to bilateral changes to their tax treaty network in light of the 2017 model revisions. So this part of the presentation basically reviews those aspects of pre-BEPS activity as they relate to the various BEPS items that are reflected in the MLI and the 2017 revisions. So beginning with the preambles, we see that most of the preambles in the pre-BEPS project treaties really just identify avoiding double taxation and preventing fiscal evasion as the goals of tax treaties in the preambles. Several do also refer to enhancing economic cooperation. Very few expressed an intention to prevent tax avoidance, and none, according to the branch reports, explicitly mentioned tax treaty shopping, which of course is one of the, is specifically mentioned in the revised preamble language. A number of the branch reports also question the role of preambles in treaty interpretation. Carmel has suggested she thinks going forward, the preamble will have a role to play because it's specific about avoidance and specifically mentions tax treaty shopping. It is interesting that it did play a role in an Indian case. So I will pass on to the next slide to Mukesh Bhutani to explain this Indian case in a little bit more detail.
Thank you, David. So it's interesting that the Azadi Bachao case found mention in the general report as well as the branch report on India. Just to give you a context here, it was not a dispute between the taxpayer and the tax administration. Actually, it was the tax administration that was defending the sanctity of India-Mauritius Treaty against a public interest litigation that was filed, alleging that certain provisions in the tax treaty were going against public interest. Now, the background is that India has not adopted for the Article 6.3 of the MLI, which, as you correctly pointed out, is the preamble and with reference to the desire to develop an economic relationship and to enhance cooperation in tax matters. This is true despite the fact that the domestic law in India, when it states out the purposes for the treaties, very clearly say that there are three important purposes. One, promote mutual economic relations, trade and investment. Two, exchange of information. And three, prevention of evasion or tax avoidance. Treaty shopping is not mentioned as one of the objectives in the report. Interestingly, when the branches were looking at the report, the Belgian and the Chilean branches pointed out that only 35% of the covered tax agreements, which is around 570 treaties, have adopted this additional preamble under Article 6.3. Now, the preamble of India's tax treaty usually provides that the convention is entered into either for avoidance of double taxation or fiscal evasion. There are some treaties which make a mention about the encouragement of economic relationship or mutual interest, or for that matter, even situation where phrases are used in the preamble itself to further a relationship as contained in Article 6.4. Next slide, please. Instead, India historically has implemented the beneficial ownership requirements either on passive classes of income, but the observations of the federal court in Azadi Bachao Andolan case, which is what I've quoted in the slides, assume significance and do find a mention everywhere. Now, what is important is the observations that most developed countries tolerate or encourage treaty shopping. And the Supreme Court also declared that the grant of tax benefits in treaties is intentional, observing that developing countries need foreign investment and treaty shopping opportunities can be an additional factor to attract them. The Supreme Court also listed out international practices where treaty network is often used to attract investment. My view is that the wordings in the preamble to India's treaty are subject of some of the court rulings, which presumably could have influenced India's decision not to adopt for including the language in Article 6.3. Thank you.
Next slide, please. I think the next slide after this, please. Okay, yes. So as Carmel explained, treaty shopping and treaty abuse was a major focus of the BEPS project, BEPS Action 6, reflected in particular the principal purpose test and the revised preamble language. The branch reports indicate a variety of responses to that concern about treaty shopping prior to the BEPS project, both domestic rules and the use of treaty-based rules, but with mixed results. And whatever one might say about the PPT, and we'll have a discussion about it versus limitation on benefits provisions as alternatives to deal with treaty shopping, at the very least, there's some consistency compared to what the variety of approaches that had been adopted prior to the BEPS project. So with respect to domestic rules, most branch reports mention the availability of domestic anti-avoidance doctrines like sham or substance over form, depending on the jurisdiction, the use of statutory GARs as well. But as I said, there have been mixed results in different jurisdictions about the successful ability to apply GARs or anti-avoidance doctrines to tax treaty shopping, applied in some jurisdictions, not others. And many branch reports say our GARs are quite new and they're untested in the context of treaty shopping. So there's considerable uncertainty about their application. Some countries have introduced specific anti-treaty shopping provisions in domestic law. The US has had anti-conduit rules for a number of years. Various countries, Switzerland, Germany, have had look-through rules that look behind the recipient to figure out whether others, investors in other jurisdictions, are benefiting from the treaty network. But again, that's sort of sporadic, it seems, from the branch reports, not widespread. Next slide, please. With respect to treaty-based rules, of course, we know that the 2003 commentary introduced a so-called guiding principle that is really one of the antecedents to the principal purpose test. And that really reflected, I think, the idea of an inherent anti-abuse principle inherent in tax treaties that could be used to challenge treaty shopping. That has been applied in some jurisdictions, Switzerland and Israel. There are cases referred to in the branch or in the general report. But a variety of other countries, my own country, Canada, for example, courts have rejected that approach. The MIL case, which was a tax treaty shopping case in 2007, 2008, rejected that approach. So again, mixed approaches to this idea of an inherent anti-abuse principle. Some countries have relied on a broad interpretation of the beneficial owner requirement to challenge treaty shopping. And so the general report refers to a number of countries that have adopted that broad view. Others have adopted a much narrower interpretation. Again, Canada with Provocar and the Velcro case adopted a narrower interpretation. And again, a variety of countries, branch reports say, well, we haven't really addressed the meaning of those words in the context of treaties, so we're a little bit uncertain about the scope of the beneficial owner concept. And of course, the OECD commentary was revised in 2014 to basically narrow what had been a broader interpretation of the beneficial ownership concept. Of course, that was part and parcel of the beginnings of the BEPS project and introducing the PPT as an alternative to deal with treaty shopping. A variety of treaties have also included specific anti-treaty shopping provisions, such as look-through rules, purpose tests, which again are an antecedent to the principal purpose test. They generally had applied to dividends, interest, and royalties, sometimes more broadly. And of course, some countries, in particular the United States, have had detailed limitation on benefit provisions. So I think the branch reports suggest a concern about treaty shopping prior to the BEPS project, but a wide variety of responses to that concern. Next slide, please. A chunk of the MLI deals with hybrid mismatches and reflected in the OECD model. I think the branch reports seem to suggest less of a concern, or maybe not concern, awareness of the issues with hybrid mismatches. It's been a concern in the US, partly, I think Phil will talk about this a little bit later in a minute or two, because of the background of the check the box rules in the United States. So the US model has included a provision dealing with transparent entities, like what is now Article 1.2 of the sub 2 of the OECD model. But very few other branches report similar provisions in treaties concluded before the BEPS project. Relatively few mention treaties with tiebreaker rules for dual resident entities requiring mutual agreement by the competent authorities, which is now in Article 4 sub 3 of the OECD model. Most have used place of effective management or place of incorporation as the tiebreaker rule. So that would be a significant change. But on the other hand, very few of the branch reports seem to express concerns about issues that are related to dual resident entities. So a lot, as it turns out, didn't sign on to that provision, because I think a lot have not expressed great concern about BEPS issues related to dual resident entities. Finally, on the hybrids, many pre-BEPS treaties had adopted already a credit method to eliminate double taxation. So, of course, they weren't going to be signing on to a provision like Article 5 of the MLI that's reflecting 23, I think that should say 23B of the OECD model, as I think. That may be a typo there. So there are already many countries who are already on board with a credit method, and therefore not signing up to the MLI on that makes sense, because it wasn't necessary for them. Next slide, please. With respect to specific treaty abuses, and Carmel spoke about a number of these, a number of branch reports indicate that pre-BEPS project treaties did have minimum holding periods for the reduced withholding tax rate on dividends. So some countries haven't signed on to that because they already had it, though they may have used different minimum holding periods. Some jurisdictions do not differentiate between dividends to a parent company or dividends to anybody else, so they wouldn't sign on to this provision because their domestic rules don't distinguish. And then, of course, some countries, if they don't impose domestic withholding tax on dividends, wouldn't be interested in this provision as well. So it's interesting to see that context of where countries are at when they encounter the MLI or the revisions to the OECD model. Most of the many of that is of the pre-BEPS project treaties include a substituted property rule for real estate companies, but generally they don't have a look-back rule like the look-back rule that is now in Article 13.4 that applies that valuation test, whether the value of the shares is principally derived from a movable property at any point within the past 365 days. So that's an innovation that didn't exist in most of the pre-BEPS project treaties, and may explain why maybe more have signed on to that. Very few branch reports mention pre-BEPS project treaties with triangular PE provisions, and only the US model treaty had a savings clause like Article 1 sub 3. That may reflect the fact that only the US really taxes on the basis of citizenship, and therefore the savings clause was particularly significant for it. I think at this point, I want to hand things over. I've referred to the US in a number of places here, and it's a good moment for Phil, I think, to weigh in on some US issues.
Thank you, David. Let me first take a step back and put things in context because there are a lot of moving parts here. It's good to summarize what the audience has heard so far. The title is Reconstructing the Treaty Network. A lot of the changes we're talking about, or principles we're talking about, or things we're thinking about are driven by BEPS. It's very helpful if you haven't done it. Go on the OECD website, type in OECD BEPS, and you'll see the 15 action items. Of those 15 action items, many of them deal with treaty issues. 4 of them are minimum standards. 2 of those 4 are treaty items. The MLI is one of the 15 action items, but is not a minimum standard. So many of the treaty issues are in the multilateral instrument, but the multilateral instrument itself is not a minimum standard. So it's really useful to go and look at that website just to get your bearings. Now on this, we have 2 simple slides here that talk about perceived abuse cases that the US has long had provisions to address, as David just said. One of them is the triangular provision, and you can see why it's called the triangular provision. The shape of these boxes on the slide form a triangle. Residence country entity owns a source country entity, and that source country entity makes a payment to a third country permanent establishment of the residence country entity. Often that residence country will not tax that income, and that permanent establishment may be in a low or no tax jurisdiction. If that's true, it raises the question, should the source country be granting benefits under the residence source treaty when the income effectively stops at the permanent establishment established in a low or no tax jurisdiction? Is there an inherent presumption that the residence country will see that income in some way more than the subject to tax provisions of the treaty require? Next slide, please. You can see a similar perceived abuse in the hybrid mismatch cases. Now, this is one flavor of hybrid mismatches. It's a hybrid entity mismatch. And again, the source country makes a payment to a hybrid entity in the third country. Now, what's going on here is that the residence country views the hybrid entity as not fiscally transparent. And so just like in the triangular provision, will not tax that income. But the source country views the hybrid entity as fiscally transparent, and so for purposes of its rules, sees that income as being the income of the residence country resident. Should the source country grant treaty benefits in this case? That's all I've got. On to you, Liselott.
I think it's actually back to me for 2 more slides.
Okay.
So just 2 other sets of issues with that are reflected in the MLI. Carmel again spoke about them at the beginning, is avoidance of PE status, and then the dispute resolution piece. So recall that in order to deal with PE status, there have been provisions in the MLI, amendments to the OECD model to deal with commissionaire arrangements. And there seems to be a variety of responses domestically pre-BEPS to these arrangements. In Italy, the Philip Morris case gives a broad interpretation for applying the dependent agent PE concept. In France, there has been a narrower approach adopted by the courts. So different countries seem to have different views about how important this issue is based on what their courts have done prior to the BEPS project. In addition, the branch reports indicate that a number of treaties include a broader definition of PE than the OECD model, so are probably less interested in these revisions because they have PE provisions like in India for assembly and supervisory activities, services PE concept in various tax treaties, the insurance PE concept that is in the UN model that Australia, for example, has adopted. So given other tools, it may be that that may explain why a number of countries maybe have not signed on to that provision. There is a variety of views about specific activity exemptions, and the MLI even contemplates different views about whether they're inherently or should be inherently, whether they're inherently preparatory or auxiliary, or should include that language in addition. None of the pre-BEPS project treaties appear to include anything like the anti-fragmentation rules in Article 5.4.1 of the OECD model. And then finally, some pre-BEPS project treaties do include provisions to prevent avoidance of PE status by splitting up contracts. Other countries have relied on domestic anti-avoidance doctrines. And I just note that this is interesting. This is one of the MLI provisions in Article 14 that didn't make it into the OECD model revisions in 2017. Next slide, please. Finally, on dispute resolution, most, if not all, pre-BEPS project treaties include some form of mutual agreement procedure, but the revisions suggest that MAP assistance a request can be made to the competent authority of both states, but most pre-BEPS project treaties say only the competent authority of the resident state except in cases of non-discrimination, when the request must be made to the state of which the taxpayer is a national. Several pre-BEPS project treaties also include limitation periods less than 3 years, and the BEPS project is intended to extend that limitation period to 3 years. There's a typo here. It says many do not allow, that should say implementation of a MAP agreement irrespective of time limits in domestic law. Many pre-BEPS treaties do include provisions for corresponding adjustments. Even treaties apparently without specific provisions, generally it's the practice to have corresponding adjustments, at least the branch reports seem to suggest, even without explicit treaty provisions. So that's sort of an end to the background on where the world was at pre-BEPS project. Back to Lisa Long.
Lisa may be frozen, and if she is frozen, then maybe we can just move to the interventions from the various interveners.
Thank you so much, David, Phil, and Mikhail. The treaty network is...
Lisa's coming in and out.
Yeah, we probably should just
Please,
move straight
go
to...
ahead from the UN. If you can hear me now.
Yes.
Yes, intermittently. Should we go to Michael Leonard?
Okay.
Michael?
Great, thank you. Thank you very much for the invitation. I'm going to give some personal views.
Please, Michael Leonard from the UN, if you start off, please. Next slide.
Can you hear me? Good. Great, thank you for the invitation. I'm going to give a few personal views but they're based on my UN experience, and especially they're on the role of bilaterals and models for bilaterals in reconstructing the treaty networks. First of all, there is another model, and that picks up a lot of the OECD model, where it's good for countries generally, developing as well as developed, but it leads in some other directions in terms of, for example, taxation based on market presence without a PE, more source taxation preserving provisions, supporting withholding taxes. It's more skeptical of mandatory binding arbitration, and it's very focused on administrability. And that's the UN model. We're very proud of it, and it's very vibrant. It's very influential in the developing world, which is perhaps most important. And in large part, that's because it's influenced by developing country practices and priorities. We think it's got a very bright future in treaty networks. Now, in a world of broad and deep consensus, a multilateral convention reflecting that consensus is very welcome. But it isn't so clear that we live in that sort of world. What about if there are wide gaps in consensus remaining? Maybe it's systemically better then to accept that these exist and to try to reduce the differences, but not resolve all of them, rather than engineer a false consensus or paper over the cracks in the wall for problems to surface later on. Let's be realistic. There's already a lack of consensus in many important areas, and therefore there are some responding variable geometries in the OECD model itself. If you look at the differences in services PEs, for example, in the UN model, in other models, in comparing the models, in bilateral practices, and in texts, articles, and treaty cases. Often we already lack a uniform approach in interpretation. And while that keeps IFA events lively, it is a sign that we don't maybe have the degree of consensus that's sometimes said to exist. Add to that, some of the building blocks of the treaty network are now outdated. There's wide agreement on that. There's disagreement about to what extent they're outdated and to what extent they need to be changed. But we do need multilateralized masonry work, and the masons aren't always going to agree. As with masonry, reconstructing the treaty network might sometimes involve some deconstructing first. Now, multilateralism is a multi-layered concept. It's not a single dimension. It's not in opposition to domestic legislation inherently. It can be part of the same ecosystem as bilateral and domestic law approaches rather than competing. It can improve those systems, and it can be improved by them. It is imperfect. Multilateralism is imperfect. The slow pace of multilateralism and the difficulty in keeping any solutions up to date, relevant, and sufficiently certain, whatever that means, remains a serious issue. And when I talk about certainty, I mean certainty for governments as well as certainty for taxpayers. And the issue is particularly relevant in COVID-19 times, where budgets can't wait for the slow processes that sometimes multilateralism implies. It's challenging to address the tax implications of changed ways of doing business as multilateral when the changes are still being rolled out. Do we need to come at it with an underlying agreed philosophy? That's one of the issues, and perhaps that underlying agreed philosophy is still lacking. In any case, we should maximise agreement and consistency of language, understanding, interpretation. But bilateral models can well reflect the remaining differences through variable geometries with pros and cons expressed, and can help build consensus on many issues, even while reflecting and clarifying a lack of consensus on some of them. Bilateral negotiations can take time, but they also have a more immediate signalling function on treaty possibilities and on domestic law legitimacy, including that taxing income based on market presence and taxation on gross are perfectly valid approaches in international economic law, not contrary to so-called prevailing tax principles as some have claimed recently. Thank you very much for the chance to comment. The models, including the UN model, are key to reconstructing the treaty network and an important part of the way forward. Thank you.
Thank you so much, Michael. So please, we are now going to hear from OECD Secretariat. Sophie Chappelle, please.
Thank you, Lislat, and hello, everyone. It's a real pleasure to be here and also to have worked with Daniel on the contribution of the OECD branch report on this topic. So I'll be very short because a lot of what we wanted to say is in that report. What you see on the slides is 3 points that I would like to make. The first one is a recognition that countries have built an amazing tax treaty network over the last century. These treaties, they have harmonized the taxation of cross-border transaction. They have eliminated a double taxation. They have created a tax environment that is conducive of investment, and that is a success. The second point on the slide is also a recognition that countries have recently developed an instrument that allows them to change or add a new standard into that vast treaty network without the need of renegotiating each one of them. And that is really important point and a big change in the landscape of tax treaties. So the mere existence of the BEPS MLI in itself is a success, but of course you see on the slides with 94 jurisdictions covered, 56 ratification and more to come before the end of the year, a change of tax treaties that is significant with over 1,700 match agreement to be modified. So that is also in practice a success. The last point is more of a question that I wanted to raise, and it is how the current discussion on the tax challenges of the digitalization of the economy may impact that treaty network. How would it do so? What I'm fascinated is the current discussion is really about finding an appropriate way of taxing M&E groups as a whole. Those that operate on a large scale across the globe and using advanced technology to reach out to markets, their activities is no longer can no longer be identified with specific geographical points. And that is one of the big issue of those challenges. But to tax such a group would require countries to deepen their cooperation beyond what they have built over the last century, beyond their bilateral relationship. And so what we may see emerging in the coming years is a new layer of cooperation, a multilateral one that would be added to the existing tax treaty network. So in a nutshell, these are the points that I thought was important to do in this topic. And on this, I will now turn to George for his view on the topic. Thank you.
Next slide, please.
Thank you very much for the invitation and to follow up on the EU, on the OECD and UN reports. The EU report was a joint effort of a group of scholars and practitioners within the framework of the so-called CFE ECJ task force. And we took a look at the intersection of the topics that we are discussing. So tax treaties, BEPS and EU law. And our report identified a couple of interesting issues. One, of course, what happens if the European Union, through a directive, for example, implements international standards, but also comes to kind of in the situation that there might be tax treaty overrides, or there might be conflicts with third country tax treaties. Secondly, we analyzed the Commission's recommendations with regard to tax treaty issues. The PPT and PE avoidance were two of the core topics. Then, of course, an old EU law topic was covered that deals with the compatibility of the anti-treaty shopping clauses, namely, or most importantly, the LOB with the EU fundamental freedoms. And here we have seen some developments because the European Commission has initiated proceedings against the Netherlands with regard to the LOB in the Japan Treaty, but these proceedings were closed a couple of days ago without any resolution. So this topic seems to be off the hot political table, so to say. And of course, arbitration is a big topic. Here we have the EU Dispute Resolution Directive since 2017, which adds quite a lot to the way tax treaty disputes can be resolved within the European Union. And finally, of course, we have the issue of treaty-based double non-taxation, so that the tax treaty leads to wide income and whether that can lead to illegal state aid. And in that instance, we have the EU Commission's decision in the McDonald's case, which kind of points in the direction that wide income is not necessarily state aid. What I should briefly mention for the future prospectively is that all these topics will be with us for a long time. So if you just think about the relationship between EU law and treaties, you can just think about Pillar 2 and the clauses proposed there, for example, a subject to tax clause or switchover clauses. They all have kind of treaty aspects to it. And if the European Union were to decide to implement Pillar 2, for example, through a directive, without the treaty network being changed, that might lead to a real interaction between EU law and its supremacy over domestic law and the tax treaty network that we have. Thank you very much.
Thank you so much, George, Sophie, and Michael. As a conclusion, things are not going to become easier, is it? I think we are clear on that. Now we're going to move on to slide 25, please. And what we thought was time now to do is to actually go and have a look at the use of the MLI to implement the BEPS standard. So I now have the pleasure to introduce Professor Daniel Gutmann from France, who also was a general reporter. We will have comments by Professor Johan Hatting from South Africa, and we will have a short comment by Carmel as well. So please, go ahead, Daniel.
Thank you, Liselott. Hello, everyone. Good morning, good afternoon, good evening. One of the key issues underlying that the questionnaire that was sent to the national reporters was whether the MLI was the starting point of a brand new treaty policy. And what we really wondered was whether by signing the MLI, jurisdictions would show a will to change significantly their current treaty policy. Now, what we see, as a matter of fact, in the domestic reports is that new priorities have been expressed by countries when signing the MLI. Of course, the first priority is the increased importance of fighting international tax avoidance. But that's not all. And when you look at the national reports in detail, what you can see is that some countries really wanted to express a commitment to a multilateral approach to international taxation, because they thought that even from a political perspective, that was probably the future in terms of fighting base erosion and profit shifting. It's interesting to see also that some jurisdictions took the same view from another perspective, let's say, and said, well, you might think that multilateralism has its drawbacks, but it has an important practical dimension, and that is that once you have a standardized treaty which is in place, well, you don't have to spend resources by negotiating bilateral tax treaties. And so it's interesting to see that for practical reasons, countries that may have a limited capacity for bilateral negotiations also took the view that the MLI was a good idea. Lastly, one of the motivations for signing the MLI is a revenue motivation. And you can see that in many jurisdictions, it was alleged that by signing the MLI, jurisdictions would gain additional revenue. Interestingly, I'd say in none of those jurisdictions, it has been actually demonstrated that by signing the MLI, there would be additional revenue. It seems to have been a kind of postulate or a hope, whatever, but it's not shown that this was an actual predictable outcome. Now, considering these goals pursued by the jurisdictions in place, but you could have expected most jurisdictions to cover all the treaties that they had when they signed the MLI. It's not exactly what the national reports show. What national reports show is that a majority group of countries has indeed covered the vast majority of their tax treaties, which are now covered tax agreements. But this fact is not enough to show that there has been a commitment to the whole BEPS project, because there might be reservations, there might be mechanisms by which a treaty, even though it's a covered tax agreement, is not impacted as such by the MLI because of existing reservations or similar mechanisms. Another finding, which is described in the general report, is that a smaller group of countries has actually listed very few tax treaties, even though those jurisdictions have signed the MLI. That's a smaller group. And when you look at the motivations for having a very low level of coverage, what you see is that the explanations vary significantly according to the country. If you read the German report, for instance, what Germany says is that the parallel existence of several instruments amending a tax treaty should be avoided. And therefore, Germany seems to favor a bilateral implementation of the contents of the MLI where available. And it's true that when you look at the German report, you can see that there are many ongoing negotiations that also take over the content of the MLI, even though the coverage by the MLI is quite low. A completely different approach is taken by Switzerland, for instance. The Swiss report reveals that Switzerland takes the view, contrary to the OECD, that the MLI does not simply coexist with bilateral agreements, but that it goes beyond that and modifies bilateral agreements. By taking this view, Switzerland has decided to list as covered tax agreements only agreements with countries that share the same view. And of course, that's a small number. Only 12 out of 105 treaties have actually been covered by Switzerland. Now, if we move to the next slide, what we will see is that the indirect impact of the BEPS action plan and of the MLI itself is quite interesting to study. In a nutshell, what you can say, what the finding of the general report is that many treaties concluded after the start of the BEPS plan have included the minimum standard package on treaty abuse and on dispute resolution. That's very clear. That's confirmed by the OECD report, which is included in the volume of the cahier. And I think if you really want to have an idea of the actual impact of the BEPS action plan on the treaty network, you should combine the reading of the general report and of the OECD report, which give a good idea, even though, of course, it's outdated already because treaty practice evolves every day, and the treaty network is changing every day. However, it's interesting to see too that relatively few treaties concluded after 2018 include other provisions, such as the provisions addressing hybrid mismatches, specific treaty abuses, avoidance of peace status, arbitration, etc. And I think that deserves to be put into perspective with what David said earlier on the pre-BEPS practice. It looks like many jurisdictions simply did not feel the need to have such provisions in the past. And maybe surprisingly, they probably don't feel the need to have those provisions now. So of course, this is a finding that is probably going to change. But it is, however, interesting to see that the MLI did not change immediately the practice or treaty policy of jurisdictions. So the next slide is a kind of summary. In a nutshell, what we can say is that if you really want to understand whether BEPS has changed treaty policy, what we could say is, yes, BEPS is a success overall. It is a success in at least to the extent that the minimum standard has been endorsed very broadly by signatories of the MLI, of course, but also far beyond the circle of MLI signatories. I'm not sure whether it's been endorsed much, broader than this core of provisions, but the future will tell us what is happening. And the second conclusion I think we can raise here is that bilateralism still has a future. It has a future for non-signatories of the MLI, of course, but it also has a future for the signatories who by many means have decided to reserve some provisions of the MLI and prefer to change their bilateral relationships through bilateral agreements. Now, this being said, I'd like to pass the floor to Joanne, who has a number of observations on that.
Thank you very much, Daniel. Good afternoon, ladies and gents from Cape Town. It's very nice to see so many familiar names in the participant box. Two questions on the slide that arises from the behaviors of countries when they met in Paris and engaged in so-called speed dating around the creation of the MLI. What do we make of country behavior to opt out of so many of the targeted treaty abuse measures which are not minimum standards? For example, the triangular PE situation or hybrid situation that Phil sketched earlier. The question that we debated amongst the panel is, does this mean that countries are actually condoning that sort of structure? So when they didn't opt in to do anything about it, are they approving of it? And should treaty benefits be granted in those triangular cases for those countries who haven't opted in? The answer is not straightforward, as we heard from Daniel. Can you derive treaty policy from positions on the MLI? The answer is probably no, because countries want to reserve some bargaining power, and so you can't really read their treaty policy from their positions on the MLI. But for legal interpretation, policy is not that directly relevant. So I do think country positions on the MLI form part of the larger legal matrix within which treaties ought to be interpreted. The question is, what is the legal value of these positions? Perhaps we should think about them in a similar way to country reservations on models. The second question here is really about the non-signatories of the MLI who appear to adopt the minimum standards in their bilateral negotiations. And here we debated amongst the panel, does that mean that these countries are viewing these minimum standards as already forming part of their legal framework? In other words, that there's sort of a type of international custom that is compelling enough so that they adopt it nonetheless. Again, this is not a straightforward question. Amongst OECD countries, there seems to be this behavior, but outside of the OECD, there is definitely not such behavior. We'll see that later on when we look at the treaty network as it evolved over the last 5 years. There are certainly countries who are not adopting BEPS treaty-related features in treaties concluded today. And with that, I'm handing over to Carmel.
Thank you, Johan. Why did some countries sign up for just the minimum standard or only a bit more than the minimum standard? And commonly those were things like the changes to the dual residence rule in Article 4 and the adoption of arbitration. Well, I think one of the reasons is that we established fairly early on in the discussion about the MLI rule that you had choices about what treaties you would put into the mix as a country. You could decide which bilateral treaties you would have would be changed by the MLI and covered, and they were called covered tax agreements. But once you'd made that decision, you couldn't offer different options. So as between the minimum standard and the optional provisions, you couldn't pick and choose who you would do those changes with. You had to have a consistency on what you opted for. So there was a rule that really governed, bound people to be consistent across their treaty network that was going to be covered by the MLI. So some countries have an historic treaty network that dates back to, since bilateral treaties were being negotiated, And the whole rule about what was being replaced and what was being changed and what was not being changed by the MLI was difficult. So because the models that they were relying on at the time were different, and so that was one factor. The second factor was that some countries, and this is sort of combined with that historic treaty network factor, but some countries had large treaty networks that they had to deal with. So, you were trying to change. New Zealand has a small treaty network of about 40 odd treaties, but some countries have over 100 treaties. And so that was a challenge. And also, I think, particularly with some of the optional provisions, particularly the provisions relating to PEs, were things that countries wanted the chance to negotiate in a bilateral setting where they could agree, make other changes to the treaty as well. Next slide, please. At the other end of the spectrum, and New Zealand is part of that, some countries did sign up for everything or nearly everything that the MLI offered. And partly this was because it aligned with their policy preferences, their treaty policy preferences for the new articles. And these are countries that maybe, capital importing countries who were supportive of the anti-abuse rules and the PE improvement rules. And I think that something that's sort of underplayed is that the model, the OECD model and the UN models have been updated, and they have commentaries that now are updated. And going forward, it is desirable to have your treaties in line with those blueprints of both the OECD and the UN to be able to rely on those commentaries. And so modernisation of your treaties, and when you're thinking about it, includes that as an element that goes into the equation of what you do. I should note that as the MLI operated, if there was a mismatch between bilateral between parties to a covered tax agreement, the default was not to adopt the new provision by way of the MLI, which I think was the right approach. Thank you.
Thank you, Carmel. I think what you have mentioned, and I also think that this was mentioned by Daniel, there is a preference for retention of bilateral negotiations. So, Daniel, why don't you give us an example of perhaps how you have seen this in practice?
Well, it's just an example which you can see on the slide, which shows that optional doesn't mean obsolete. If you look at the treaty between France and Luxembourg that has been concluded in 2018, it's very interesting. On the left column, you have all the provisions that Luxembourg chose to opt out of in the context of the MLI. You can see that's quite a lot. So these are optional provisions. It's not the minimum standard. You could have expected Luxembourg simply to disregard these provisions in its treaty, in its bilateral relationships, but that's not the case, at least in the case of France. In many cases, those provisions are actually included in the treaty between Luxembourg and France. So that's interesting because it shows that you might have opted out in a multilateral context and opted in a bilateral context. The provisions that are not included in the bilateral treaty are the ones for which both countries have made reservations in the MLI, with one exception, by the way, which is the splitting up of contracts. Now, since I have the floor, we also wanted to attract your attention on another issue, which is an implementation issue, and we can go to the next slide. An implementation issue that relates to the way the MLI is actually introduced in the domestic legal system of its signatories. It envisaged that covered tax agreements could be reviewed in the form of consolidated versions or synthesized versions. The two concepts are not synonymous. It is well known that the OECD has favored and encouraged jurisdictions to have synthesized versions, that is, versions of bilateral tax agreements where the text of the MLI is actually reproduced in boxes, which are inserted after the relevant provisions of the covered tax agreements. A consolidated version is, of course, much more ambitious because it aims at having one consolidated text that does not even distinguish between the MLI impact and the rest of the treaty. Now, what we see when we read the national reports is that the majority view is clearly in favor of the OECD advice. So most countries have published synthesized versions of their covered tax agreements. However, it's interesting to see that while some countries have actually consulted with each other to reach a common understanding of the impact of the MLI, others haven't. And the outcome was predictable. That's it. You have cases where synthesized versions published by two parties to the same covered tax agreement don't look alike. And that's a problem. That's a problem for taxpayers because, of course, taxpayers are going to rely in practice on the synthesized version that has been published by their residence country. And the question is whether they can actually rely on that, you know, if they have complied in good faith with the wording of a synthesized version. That's an issue which is addressed by only a very few national reports, but it's a serious one. Of course, that's a tricky one, but the answer seems to be, at least in the majority of jurisdictions, that since synthesized versions don't have a legal value of their own, they cannot be relied on by taxpayers. But if you go beyond the problem of taxpayers' treatment and protection, you have a tax certainty, a legal certainty issue. And so probably one of, a good practice would be for countries simply to consult with each other when they publish a synthesized version. Now, if we want an example of that, I think Mukesh is going to give us a very interesting one. Mukesh.
Thank you, Daniel. Next slide, please. As you correctly pointed out, the synthesized version is not mandated by MLI, and hence it has revealed ambiguities about the way in which MLI will modify the covered tax agreement. The Australian branch called the synthesized version for educational purposes, and the Austrian report called it as for courtesy purposes. Now, the absence of formal notification of the amended tax treaty, in my view, leaves the element of uncertainty. The text of the applicable law itself is not known, much less its interpretation and contours. The leeway whereby country-specific synthesized versions are permitted further adds to the taxpayers' woes and differences of opinion amongst the tax authorities. There are also cases in which the implementation of the operating mechanism of the MLI may reveal interpretation of the underlying covered tax agreement. Further compounded by the prevailing view that whenever conflict appears between the synthesized version and the tax treaty as modified by MLI, the latter prevails, and hence the taxpayer cannot argue that he could legitimately rely on the text of the synthesized text. The Norwegian and Argentinian reports have raised a very interesting question on taxpayers' good faith compliance with the synthesized version, or one who committed an excusable mistake, whether they should deserve a legal protection. It is observed that the synthesized version generally provide in an explicit manner that the original text of the covered tax agreement prevails, in which case there is no possibility for the taxpayer to develop a good faith argument that has been taken by the branch reports in Norwegian and Argentina. I like the Swiss approach. They kind of distinguish between a amending view, which is what they call it as a good approach, which will guide the taxpayer, instead of a larger practice of MLI changes being existing through a coexisting view, which is what the view is being promoted by the OECD and followed by many, many countries. The synthesized version released by Singapore, insofar as India-Singapore is concerned, reveals that the existing preamble in its treaty with India is deleted and replaced with the new language, while the Indian text states that the new language is included in the existing preamble. It can make a lot of difference to India-Singapore Treaty. I'm not going to get into the details in the interest of time as well. Next slide, please. I just wanted to talk about two other inconsistencies in the synthesized version. The Indian version of the text for Japan Treaty states about Article 17.1 of the MLI replacing Article 9.2 of the Covered Tax Agreement, while the Japanese version states that the MLI article shall apply to the convention. Now, this is clearly an inconsistent because as per Article 9.2, the competent authorities have to be consulted for an agreement, makes it a condition to provide corresponding adjustment. However, Article 17.1 of the MLI provides that in case of necessity, competent authorities shall only be consulted, implying that it is not mandatory. Now, this could put Japanese investors inbound into India at a disadvantage. Another view of inconsistency is the India-UK synthesized text. It labels different understanding between the two countries on applicability of the principal purpose rules to various forms of passive income, such as royalties and fees for technical services. India has not included these provisions in its notification under Article 7 of the MLI, and hence the inconsistency apply. In my view, Article 11.12 is narrow in comparison to Article 7. Another important being that Article 11.6 states, it does not state the objective taste, which means implies that even if a benefit is availed within the object and purpose of the double tax treaty, relief shall not be available. So this could put UK investors to disadvantage, because now they are seeing that besides the principal purpose test, the LOBs that have been prescribed in the relevant articles for passive forms of income will also apply, which is not UK's view. Thank you.
Thank you so much, Mukesh, for those very interesting examples of where there could be some real difficulties with the use of the synthesized text. And what has striken me as well with Daniel's and Phil's presentation is the low uptake of the triangular PE issue, which is quite surprising even in the Luxembourg-French Treaty. And as Phil outlined, the use of the triangular PE in anti-abuse situations. Well, one country, coming back to Phil, that did not sign up to the MLI is the US. Phil, please, could you give us some understanding of why?
Yeah, sure. Let me highlight at the outset that it's not that the US doesn't think reconstructing the treaty network is useful. It's just that it's not going to do it through the MLI. And the reason is simple. Many of the measures that are in the MLI are already in the US treaty, model treaty, and in most of our other treaties. There are also other considerations. But we like to think we were the progenitors of many of the provisions that are in the MLI, so it's not necessary. Next slide, please. So here's some examples of areas in which we've long had treaty provisions. Was mentioned fiscally transparent entities, dual resident entities. We have, of course, detailed limitation on benefits provisions. We have minimum holding periods to qualify for direct investment dividends, reduced withholding tax on direct investment dividends. We, as I mentioned earlier, have triangular provisions in many of our treaties. The saving clause is unique or near unique to us, but also is in the nature of anti-abuse. And we're going to talk later about the mutual agreement provisions, which I was interested to hear Michael Leonard talk about skepticism in the UN model to mandatory binding arbitration. I found valuable Michael's comments overall and Sophie's and Georg's on reconstructing the treaty network going beyond the MLI. And again, that's where the US may find these provisions most relevant, or the concept most relevant. Next slide, please. We prefer our LOB over principal purpose tests, and I can we'll talk later about comparing the principal purpose tests to our LOBs and some experience I had, I think, trying to get a principal purpose or main purpose test through the Senate. We have backstops in our domestic law, substance over form, step transaction. We've long had an economic substance doctrine. It's been codified in recent years. We also have political considerations. Our Senate may have concerns with multilateral instrument, and this departing administration, as many of you know, is not the most multilateral of all administrations. That may change with a Biden administration. We'll talk in a minute about that. The arbitration provisions are a view of mandatory binding arbitration is frankly stronger than what we see in the MLI. And, an unstated reason, the U.S. may like its negotiating leverage in bilateral discussions more than it did in the multilateral, the negotiation of the MLI. Next slide, please. So we've had an election, as I think many or all of you are aware. We, despite what the current president says, will have a change of administration January 20th, and the Biden administration, I believe, will be more multilateral. Having said that, people who really focus on U.S. politics know that there's a more progressive wing to the Democratic Party and a more centrist wing. If we want to divide it, into two, of course, it's much more subtle than that. But to the extent treaties in general are viewed as reducing tax on multinationals and wealthy individuals, those who are more likely to have cross-border income and assets, we may have some movement in the other direction on our treaty program generally. I don't expect that to be a major focus, but historically, the Republicans have been more sympathetic to our treaty program to the extent there is a concern may be raised by the Democratic Party, again, which is going to control the administration, the executive branch, but may not control the Senate, which is responsible for approving treaties. And if the Senate does remain in Republican hands, not only may we see that dynamic, but we saw one senator, we'll talk about this a bit more, hold up treaties for as long as 10 years, some of the treaties and protocols. We can talk about why that was. I don't believe it was a good reason, and it required an expenditure of valuable time of the Senate to overcome that one senator's hold on these treaties. It was overcome for our protocols, not for our full treaties, for reasons that are a bit beyond the scope of this panel. But we might see overall a more multilateral inclination with the Biden administration.
Thank you, Phil. Interesting comments, and I think especially for us who've been involved in the BREPS projects, etc., is to hear, and I think it's true, that many of the anti-abuse provisions that are in the MLI and that was agreed in the BREPS project are actually covered by the US in their treaties. I think the one point that you mentioned that perhaps is shared by other countries is the negotiation point. Next slide, please. We will now just finish actually before coffee break, and we're a little bit late, but we actually started a bit late as well. Just a couple of countries from our region here in Latin America, why they did not opt for the MLI. And I think what we can heard from Brazil is that they didn't want to have problems and complexity of interpretation of the MLI. Ecuador has actually not been part of the member and work on the inclusive framework. And we have other countries like Paraguay who have signed treaties, but mainly with Middle East countries. and hasn't shown very much interest in being part of the MLI. So those are a little bit of the reactions outside the particularities of the US. We're going to have the questions up. So the next slide, please. We're going to have, I suppose we can take 5 minutes for a coffee break, if that's okay with everyone. We have these 3 questions and we're going to vote at the end of our session. So please keep the questions up, take 5 minutes for a coffee or straight your legs or a visit somewhere, and come back in 5 minutes, please. Thank you. One of the most important measures in MLI is to reconstruct, the treaty network, is probably introduction of a treaty GAR in the form of the PPT. So please, Daniel, set the scene for us.
Yes, thank you, Liselott. As you've just said, one of the key issues is really to determine whether the PPT, which is to be found in the MLI, is going to change the way tax treaties are being interpreted and the way taxpayers behave in the future. When reading the national reports, the question that we've had to this, the answer that we've had to this question is, it's really going to depend upon the jurisdictions, and besides that, no one really knows what is going to happen. The reason why I'm saying it depends according to the jurisdiction at stake is that in some jurisdictions there was no PPT, or there was one, but it was not really applied or not taken seriously. So of course, in those jurisdictions, the introduction of a new rule in the form of a PPT is likely to change the situation, provided, of course, that judges, are not tied to their past practice. So that's a real situation where it's difficult to predict in advance what is going to happen. In other jurisdictions where there was already a PPT, there are several issues. First of all, one may wonder to what extent the PPT, which is now to be found in the OECD model and in the MLI, is going to be a new standard which is added to the existing ones, to the domestic GAR, to the EU GAR, or maybe I should say to the EU GARs, in which case you have an accumulation of possible standards of abuse. And that could be quite complex to manage on a daily basis. Now, there is also a possibility that countries which did have a PPT in place or a GAR in place are going to change their interpretation to conform with the new PPT, which is the outcome of the BEPS action plan, in which case there would be a tremendous impact that would go beyond actually the BEPS action plan. And one might even imagine that the new definition of the PPT is going to have an impact in domestic law and for domestic operations. It could also be the case that exactly the opposite is going to happen, and that at the end of the day, nothing is going to change, because those jurisdictions that may have an existing GAR, which may be drafted in a more restrictive way, are actually going to keep what they have, and courts will interpret the new GAR in the light of their existing more restrictive GAR. So as you see, and when you read the national reports, virtually every situation is contemplated as a possible one. So it's very difficult to predict the future in this respect. And one good example of that is probably Canada, which is the reason why we've selected the Alta Energy case for the next presentation, which is going to be done by David.
Thank you, Daniel. So let me just quickly summarize the facts and then explain how this case that involves the Canadian GAR is also relevant to the potential application of the PPT. Next slide, please. So this case involved an investment into the Canadian oil and gas sector through a Canadian subsidiary called Alta Canada. After the structure was originally set up. The investors decided this structure was not effective from a tax perspective, among other things. A disposition of those shares of Alta Canada by Alta US LLC could lead to capital gains tax in Canada under the substituted property rule in Article 13.4. So the investment was restructured, and maybe the slide can move forward, to set up a subsidiary in Luxembourg, and through a partnership that's sort of incidental to the facts, and the shares of Alta Canada were sold by Alta US to Alta Luxembourg for a note. That sale happened at fair market value, and at the time the sale occurred, the Canadian revenue authorities accepted that the fair market value was equal to the cost base of the Alta Canada shares, so that did not result in tax in Canada. A little bit more than a year later, so on to the next, a bit more, sorry. A little bit more, and now further yes. So about a year later, the shares of Alta Luxembourg, or Alta Luxembourg, that is, sold the shares of Alta Canada to Chevron Canada Limited, resulting in a $380 million gain. Move forward, please, and then next slide. Next slide, please. Okay, so the taxpayer was assessed on the basis that the Alta Canada shares were taxable Canadian property subject to source taxation in Canada. The taxpayer appealed on the basis the gain was exempt under Article 13.5 of the Canada-Luxembourg Treaty and excluded from Canadian tax under Article 13.4, the substituted property rule for real estate companies, or companies that derive their value primarily from a movable property, because of an exception, the premises exception in the Canada-Luxembourg Treaty that excluded shares, the value of which was derived principally from property in which the taxpayer carried on its business. And we'll see that's treaty provision in a second. There were various arguments that the Crown made, but in addition to the other arguments, the Crown sought to apply the Canadian GAR, which is very similar to the PPT. So next slide, please. Here is the provision in the Canada-Luxembourg Treaty, and you'll see that the first part of it is very similar to the so-called substituted property rule that you see in many treaties, looking through shares or interests in a partnership, trust, or estate, if their value is derived principally from a movable property, and granting source taxation in those circumstances. But then having this exception, in the Canada-Luxembourg Treaty, there are two exceptions. One that I'm not referring to, the substantial interest exception, which is the latter part, was at issue, people may recall, in the MIL case in Canada. The first, being this premises exception, says the term immovable property does not include property other than rental property in which the business of a company is carried on. And so the argument by the taxpayer was, we're carrying on the business of oil and gas exploration in that immovable property. Next slide, please. So as I said, there was an argument at trial about the interpretation of that language, but beyond that, there was a question of the application of the Canadian GAR, assuming that that language of the treaty applied on its own terms. And if you look at the Canadian GAR, it's got elements that are very similar to the PPT. The PPT applies to an arrangement or transaction that has resulted directly or indirectly in a tax benefit. The Canadian GAR applies to a transaction that would, but for the GAR, result in a tax benefit, and that can include a benefit under a treaty. The PPT applies if it's reasonable to conclude that obtaining the benefit was one of the principal purposes of any arrangement or transaction. The Canadian GAR has a double negative. It says it applies if the transaction cannot reasonably be considered to have been undertaken or arranged primarily for purposes other than to obtain the tax benefit. You can reverse that and say, in other words, if it's clear that the treaty was, or the transaction was undertaken for non-tax reasons, or for tax reasons, that is, then the GAR will apply. And then the final element is the object and purpose aspect, or in the Canadian GAR, a misuse and abuse test. The PPT will apply if granting the benefit is not in accordance with the object and purpose of the relevant provisions. The Canadian GAR applies if a transaction may reasonably be considered to result in a misuse of specific provisions or an abuse having regard to provisions read as a whole. And that can again include treaty provisions. And in applying that misuse and abuse test, the courts have said you look to the object and purpose of the provision or underlying rationale of the provision. So very similar to the PPT. People may know that in the Canadian context, it's the third of those elements that is litigated the most, not in fact the purpose of the transaction, but rather the object and purpose of the relevant provisions. So we'll see that that's really the issue that's litigated in Alta Energy. Next slide, please. So the Crown made a variety of arguments, and I think we would see these arguments made in the context of a PPT. The first two arguments are really related, focusing on Article 13.4, but in the context of the treaty as a whole and in particular, Articles 1 and 4. So the Crown argues that the transactions contradict the purpose of Article 13.4. According to the Crown's appeal, it's now been appealed to the Supreme Court of Canada. The decision will be decided sometime next year, presumably. And the Crown argues that the purpose of that provision is to encourage investment by each other's residents, not by residents of third-party states. And that links into the second part of that argument, which is not only contradicting the object and purpose of Article 13.4, but the transactions contradict the very purpose of Article 1, according to which treaties apply only to residents of one or both of the states, and to the definition of residents in Article 4. Why? Because they permit an investment that's been made by residents of third-party states to be liquidated free of tax when those persons could not have accessed this particular tax benefit directly by restructuring, that is, into Luxembourg. And the final argument is that the transactions essentially contradict the purpose of the treaty as a whole, which is to prevent double taxation, not to facilitate or permit double non-taxation. Now, one of the problems with that final argument, of course, is that we're dealing with a treaty that is a pre-BEPS project treaty that doesn't talk about a purpose being to avoid or to prevent avoidance, including by treaty shopping. Next slide, please. So the Crown lost both at trial and at the Federal Court of Appeal. The decision has been appealed to the Supreme Court of Canada. But interestingly, at both levels, particularly at the Federal Court of Appeal, the court concluded that it was impossible to identify any clear rationale for the relevant provisions beyond their text. And therefore, since the taxpayer adhered to the text, then that was consistent with the purpose because the purpose was fully expressed in the text. And further went on to say that a purpose to prevent double taxation isn't apparent from the provisions of the treaty. The Federal Court of Appeal did, however, signal that this involved a pre-BEPS treaty, that there have been subsequent measures to curb, as it said, treaty shopping, and therefore a decision might be different going forward. As I say, the Crown appealed the decision. The Supreme Court of Canada granted leave. And so one question that's a bit puzzling to Canadians is why did the Supreme Court of Canada grant leave, given that this is a pre-BEPS project, pre-MLI, pre-PPT treaty, and is it going to have effect going forward? My speculation is it's more about the approach the Federal Court of Appeal adopted to interpreting the object and purpose of the provisions, which adopted a very textual approach rather than trying to go behind the words of the provision to determine their underlying rationale, which has been an issue in Canadian GAR cases, and I think will be an issue in interpretation of the PPT, which leads into the next slide. So what are some of the key interpretive questions? Well, of course, first big question is, how does one determine the object and purpose of relevant provisions, particularly a provision like Article 13.4 in the Canada-Luxembourg Treaty that's not included in the OECD model? So you don't have commentary to rely upon. We had a discussion in the panel about things that might pay attention to. Johan has did some interesting research into the potential history of this treaty provision. It's in a number of other Canadian treaties. It's not clear whether it was requested by Canada or the other jurisdiction, but the fact that it's in a number may suggest it was requested by Canada. So the history of the treaty provision, other treaties may be relevant. Interestingly, throughout the cases thus far, there's been no reliance on extrinsic evidence to try to establish the object and purpose of Article 13.4. Instead, it's merely arguments that are inferred from the text of the provision about what its purpose might be. And of course, that's always not the most robust method of determining what the object and purpose of a provision is. If you want to go behind the text, it would be nice to have something more substantial than simply inferences from the text. Another question that will arise, I think, on the appeal in Alta Energy, but also in the PPT is of what relevance to that interpretive exercise of the OECD commentaries. They will presumably be more relevant for provisions that match the OECD model. There will be a number of questions about subsequent commentaries, whether they are going to be relevant in interpreting the object and purpose of a treaty provision that preceded those commentaries. And another question that will arise presumably is of what relevance are OECD commentaries for non-members of the OECD? Do the commentaries have any relevance? Finally, I think there are some interesting questions about how a provision like the PPT will apply to holding companies like Alta Luxembourg. So the PPT and the preamble language talks about not permitting treaty benefits that extend or not permitting treaty shopping that extend treaty benefits to residents of third countries. Well, to what extent do the investors have to be from third countries or from the country where the holding company is located? If the holding company has sufficient economic substance that it's got something more than just a conduit or a flow through, what substance is required? I think all of those questions are going to be at issue in applying the PPT to holding companies like Luxembourg. And one final question might be, should the PPT apply differently to investments that are restructured to take advantage of a favorable treaty versus investments that are structured at the outset to take advantage of a favorable treaty? In the Alta Energy case, it seems as though the Crown's trying to argue it's the restructuring that's abusive, but had it been structured this way from the outset, it might not be. I'm not sure in the PPT context it would make a difference, but I think in the context of the existing rules, the Crown is trying to draw a distinction between those two circumstances. So I'll stop now, and then I think others will come back to comments about interpretation in the PPT.
Yes, thank you so much, David. I think illustrating the difficulties of the PPT was one of the things that we wanted to raise in the panel, and to have this case with the similarity of the Canadian GAR with the PPT drafting, I think was very, very good and illustrative for our audience. So thank you for that, David. Johan, could you now please give us your view on the interpretation aspects of the MLI, please?
Yes, thank you very much, Lieselot. So in this section, I'm going to come back to the Alta case, but I don't think the Alta case is exhaustive of all the interpretation issues that one can find under MLI-affected treaties. And what do I mean by MLI-affected treaties? Essentially, you must read, these are treaties covered by the MLI, of course, but also treaties not covered by it that incorporates BEPS treaty features. So beyond the OECD and G20 countries and MLI signatories. As we will see later, most treaties today, ladies and gents, are signed by non-OECD countries. So the first question then is, what precisely are the BEPS materials that one can consult when you interpret a treaty that contains BEPS features? Now, most obviously for the MLI covered treaties, that would be the explanatory statement, and that contains a direct reference to the final BEPS report. So that's rather straightforward. But what about other BEPS materials? The organizations like the United Nations and the IMF and so on have produced very detailed documentation dealing with BEPS concerns arising from tax treaties. And are one precluded, or are you allowed to look at those materials? It perhaps depends on where in the world you will sit and administer a treaty. Firstly, why is it important to take account of these differences? If one looks, for example, at the UN or the IMF's materials on BEPS treaty-related concerns, there's different priorities, and there's also different interpretive positions being taken in those materials. Some classic examples is what is the meaning of beneficial ownership? The UN now takes a very different approach from the OECD. The relationship between general anti-avoidance rules and tax treaties, interpretive issues around offshore share sales, very relevant in certain parts of the world, not really addressed in the OECD BEPS material, some of them, others addressed in other BEPS materials. So that, I think, is going to be an issue for the future, and that no one single organization has got a monopoly over BEPS concerns and BEPS materials. And some organizations suffer legitimacy issues. That's one thing, one of the key things that we learned from the IFA General Report in 2017, written by Steve Shea and Alison Christians. The second bullet point here is the question is, will everybody interpret MLI-affected treaties with reference to the same materials? My view is perhaps not. I think in the post-BEP landscape, there are distinct interpretive communities that one can identify. I think tax advisors now look at tax treaties from a different perspective. They have a different framework for interpreting treaties. It's the so-called managerial approach. It's not only based in narrow legal questions about the weight of a certain document, but it's also based on expected behaviors by administrators, uncertain positions that need to be reflected in financial statements, about the reputational impact of advice on clients and so on. So, and of course, when you operate in a multi-jurisdictional setting, regulators will take different positions depending on which BEPS materials they are going to consult, because that reflects their policy priorities. And of course, domestic courts, we know this well, have adopted different approaches to supplementary materials, even within OECD countries, but also outside of OECD countries. And I think those disparities will continue. I do not see as realistic any perspective that we're going to attain some form of multilateral interpretation of the MLI anytime soon. There's been mention of the Conference of the Parties under the MLI, but not much is known about their role at all. So, next slide, please. Looking a bit closer at the PPT, of course, the PPT is the main event of the whole reconstruction of the treaty network. It's the introduction of GAR, plus then the other administrative attempt to put life back in a half-dead animal. That's the mutual agreement procedure. As a preliminary point, I view these, my view is these are treaty administration provisions. The PPT mixes in normative elements about treaty interpretation, but it's essentially an administrative tool that puts what a judge normally does in the hands of a tax administrator. But it doesn't do that in a courtroom setting. And I think most taxpayers' experience of the PPT is going to be at the level of where administrators handle this new mechanism. So firstly, what is at that level, what is the value going to be of the BEPS reports and the commentaries at the administration of treaty level? I think there's a technical basis to say that many elements of the PPT is going to be interpreted for the time being with reference to domestic law, especially where countries have general anti-avoidance doctrines or legislation and case law. I think the Alta case, David just illustrated that to us. So countries are going to project their experience with tax avoidance onto the PPT. And because countries have different levels of tolerance of where the acceptable line and unacceptable line with tax avoidance is, we are going to see uneven application of the PPT, at least initially. The OECD commentaries is going to lead to tension with domestic law. I think the examples in the commentaries perhaps is a prediction of that. Those examples, some of them are clearly based on cases, Bank of Scotland, for example. Other examples are not really hard cases. But what is important is they seem to turn on elements that are not expressed in the text of the PPT. Some of those examples imply that the PPT has got a business purpose test. It's not written in the PPT, but if you look at the solutions in the examples, that's what they suggest. Now, in some countries, courts, Canada, South Africa are examples, have said that you can't imply a business purpose test in general anti-avoidance doctrine because the result of that is that you might neutralize tax incentives. So these are issues that still are going to be, that need to be settled and are going to lead to tensions in different approaches. Future changes to the OECD and the UN commentaries on the PPT are going to be very relevant. The issue here really is peer reviews of countries. When countries are expected to comply with OECD minimum standards, that's going to mean future updates of the models are going to be relevant because over time the standards need to be equal for everyone. And then lastly, before I ask Carmel to comment, is will PPT interpretation require extrinsic evidence? This is an issue that David already alluded to in Alta Energy. In Alta Energy, the court refers to the shared mutual intention between the two countries. Does that mean that we need evidence of the so-called travaux préparatoires, in the words of the Vienna Convention, the treaty negotiation papers and so on? In some countries, courts are clear. Those are not inadmissible types of evidence, and interpretation are for the judges. So thanks very much. At this point, I'm going to ask Carmel to comment.
Thank you, Johan, and I agree with everything you've said, that a lot of it is going to come down to how one interprets these things, these changes, particularly in relation to the PPT, in light of how they've approached their domestic law, anti-abuse provisions. You know, we didn't, the OECD didn't leave things completely in a vacuum. They provided a lot of examples to illustrate how they thought the PPT would apply, and it's natural that the examples they provided were probably at extreme ends of the continuum. But of course, the whole point of the PPT is that you know, unlike the LOB, is that, and it's not a criticism of the LOB, but you're not looking to provide a roadmap as to how to circumvent the PPT. It's a general anti-avoidance provision, like a number of countries have in their law. I'm going to also anticipate a discussion that's coming up in terms of our discussions in our preparatory meetings. And one of the questions that arises is whether the PPT is a subjective test or an objective test. And I can see how some countries would review it as a subjective test, that that either the taxpayer or more importantly the administrator is seeing it as a subjective test. I can tell you that in New Zealand we have a general anti-avoidance rule, which is, like Canada's, very similar to the principal purpose test, and we regard it as an objective test. And we had an interesting discussion in our preparatory meetings where I think Phil West, and he can respond to this, called it the subjective subjective test. But we view it as objective because we look at our administrators would look at how a court would approach something, and that they dial back and think about how they should approach this in light of that. And they're not really trying to get into the taxpayer's head about what view they had in relation to any particular arrangement, but rather what the evidence, what the facts show in terms of how you deduce how the taxpayer might have been thinking about it. But with that, I think we should pass on to the next speaker.
Thank you, Carmel. Last slide from me, and I'll be brief. if I'm correct that the PPT is essentially tax treaty administration law, then I think I do speak for others as well, that it's rather disappointing that so little attention was given to the administrative operation and the procedures around the PPT. This is critical for taxpayer certainty. One area is, of course, countries with established general anti-avoidance regimes have detailed procedural rules in domestic law for how this type of legislation operates. Some countries have specialist GAR panels that vet proposed application of these types of rules. There's sophisticated taxpayer notification procedures upfront, giving opportunity to disclose extra information and so on. And there's an absolute paucity, at least in the OECD's materials, about how the PPT is supposed to operate at the practical domestic level. Then secondly, the burden of proof. Again, in domestic law, there will, for some countries, be very detailed rules that regulates, of course, the statutory onus, but also the burden of proof and how that shifts in the application of the PPT from one element to the other. Generally, it tracks the so-called proximity to evidence principle, so who's closest to the evidence carries the burden. Most of the stuff in the PPT, and this comes back to the objective-subjective debate, if it's objective questions, speaks more to policy issues, the purpose of a specific treaty clause, the purpose of the treaty, you would expect the burden is on the tax authority. But if it's subjective and it's about what's in the mind of the taxpayer, it affects the burden as well, and it might shift elsewhere. So again, much will be debated and said about this question in future, I'm sure. Last point, Carmel anticipated it, and I'm just going to reiterate it. The application structure of the PPT is going to be well, for some confused, other fused with domestic issues, and the best one to illustrate it is this age-old debate in some countries about whether the approach is subjective or objective. And I should say, speaking from South Africa's perspective, this is not only about the purpose of the arrangement. Other elements like whether a taxpayer indeed enjoys a benefit is also colored by that question. Whether there is indeed an arrangement can also be affected by these debates. So perhaps IFA congresses in future will debate this a lot, and I'm already tired at the thought of that. But thank you very much.
Thank you, Johan and Carmel. On this last point, PPT and domestic law, perhaps Mukesh can give us some comments from his point of view, please. Go ahead, Mukesh, and next slide, please. Thank you.
Thank you, Liselet. Well, the general report has expounded the MLI implementation challenges arising not just from a constitutional law perspective, but also the complexities owing to the amalgam of the operative mechanisms versus the substantive effect of the MLI. Now, more importantly, not all country tax administrations, particularly the judicial authorities, can be expected to appreciate the finer distinctions and give effect to such underlying intent. The peculiarities of respective countries' legal system is expected to lead to complexities and controversies in the MLI transposition. The legal construction of the treaty network is therefore incomplete without a detailed guidance, the point that Johan also made, which averts, the detailed guidance averts to situations likely to arise out of the interface of the domestic law. And the guidance, in my view, should not be a one-time exercise, and instead it should be a dynamic enough to address newer issues that will come up. On the VCLT perspective, the general report reveals glaring perspectives from an international treaty interpretation point of view, particularly the explanatory statement, whether the explanatory statement of MLI constitutes a context, supplementary means, or is it all relevant for interpretation seems to be an open issue. Such a situation is not conducive as the explanatory statement forms the core basis indicating the intent and the objectives of the MLI. The exclusion of explanatory statement in the MLI interpretation process could therefore have been avoided. The Belgian example is very interesting. It basically codifies the explanatory note as a hard law. In my view, it's worth emulating and it should be explored, but it's an outlier situation. In the alternative, the explanatory statement may be propounded as an official interpretation of the MLI, such that it receives, at least in practice, the same status as an OECD commentary. Another issue is whether a contracting jurisdiction has rightly applied its right to reserve an article in the MLI. For instance, Norway has reserved the rights to Article 17 not to apply, as it believes that its cover tax agreement with India already contains such provision. However, a perusal of Article 9.2 of the CTA reveals that the other state may make an appropriate adjustment, while Article 17 requires such adjustments to be mandatorily made. The explanatory statement also states that such a provision, which gives discretion to a contracting state to make the adjustment, cannot be reserved, prompting the Indian branch reporter to remark that the reservation made by Norway seems to give an incorrect interpretation. The explanatory statement states that it reflects the agreed understanding of the negotiators with respect to the convention. And accordingly, the provisions contained in Article 3 through 17 should be interpreted in accordance with the ordinary principle and the good faith principle. Now, this is a transparent reference to Article 31(1) of the Vienna Convention of Law of Treaties. The general reporters, as per the general reporters, it is difficult to ascertain whether the explanatory statement should be considered as an element of context under 31, or Article 31(2) defines the concept of context in the interpretation as comprising, including its preamble and annexures. A, any agreement made by the parties with the conclusion of the treaty, or any instrument made by one of the parties with the conclusion of the treaty. The general reporter's view is that the explanatory note does not seem to fall within the scope of context, because a document prepared by participants in the ad hoc group or in the subgroup on arbitration may not be considered as an agreement relating to the treaty. It does probably not fall within the scope of B as well, either because it is doubtful whether it has been accepted by the parties. We also believe that Article 31(3) coverage is doubtful in light of the latter reservations and options, and they may have been adopted in a unilateral way by the parties to the MLI. As per the general reporter, it should certainly be considered as a supplementary means of interpretation. On the retrospectivity of the MLI, by default, retrospectivity broods complications and has dire effects on taxpayers. Suggestions in the general report that there is a possibility of MLI being given a retrospective effect does not present an inspiring proposition. It would be rare to find that the exact text of the MLI provision existed in the unamended cover tax agreement, and hence the argument that MLI represents a clarification may not be the current basis to claim retrospectivity. Needless to say, Article 28 of the Vienna Convention prohibits that. I was trying to figure out what would be an apt code for the ex post or retrospectivity, and I figured out that William Safire, the American author and lexicographer, also a political speechwriter, says that when we apply today's morality to yesterday's mores, we indulge in an ex post facto judgment. Well, that's apt, I would say. Now, I just wanted to also discuss the Indian law, which was amended from April 2020, because it clearly lays down a proposition that the MLI does not have a retrospective impact. Next slide, please. Now, this slide essentially lays down the Indian GAR versus the PPT proposition, and it's very relevant given the Alta Energy case that we spoke about. While PPT is only confined to treaty situations, the GAR applies both in domestic situations as well. The premise of the PPT is that a particular tax benefit is not in accordance with the object and purpose, while the GAR applies where one of the tainted elements applies, and we have the same tainted elements as it prevalent in other common law country, the commercial substance test, the sham transaction, the bona fide test, and transaction not being on an arm's length basis. What is the effect of this? The PPT can only result in a denial of the tax benefit, whereas a GAR can result into recharacterization of a transaction. On the burden of proof, really, I don't see any difference between the PPT and the general anti-avoidance, where the burden of proof rests entirely on the tax administration. Now, this is unlike GAR, where the tax administration in India, at least from a reading of the Indian law, has to prove only a prima facie existence of abuse, and thereafter the burden shifts to the taxpayer. It's also interesting to note that India has grandfathering provisions with some of the treaties. The domestic law has certain carve-outs, including grandfathering of previous transactions with select by way of select protocols. And interestingly, all of these protocols are post-2014 BEPS development. The PPT does not accommodate any carve-outs, and hence taxpayers are at a risk if the PPT law is applied. On the approval, the GAR provisions are fairly elaborate. The application for PPT does not require any special status. I just thought I'll also point out to you that 2003 commentary on Article 1 of the OECD Model Convention affirmed the guiding principle that the benefits of double tax convention shall not be available where a main purpose for entering into a transaction was to secure a more favorable tax treatment. It is not very clear that all jurisdictions have agreed on such guiding principle, though Canada and Norway seems to suggest that it is unclear whether this principle, even if accepted, applies to tax treaties negotiated before the 2003 revisions of the OECD commentary. Next slide, please. Now, the amendment of April 2020 articulates India's position. However, that's simply said, the amendment, more importantly, does not make any reference to the MLI specifically. Instead, it is limited in its scope to permit anti-avoidance concerns as one of the primary objectives of the tax treaties, and hence the exact status of an MLI's transposition in the Indian law is unascertainable. And I have no doubt in my mind that when these cases go on trial, that's precisely what the Constitutional Court will look at it. The amendment only enables the government to execute tax treaty with such objectives, but is only optional and not binding in my view. Thus, no larger overall mandate exists to effectuate MLI objectives in the Indian tax treaties. A question arises if an MLI provision can be declared, can be regarded as a declaratory or clarificatory in nature. The Austrian report suggests that the wordings of the preamble in Article 6.1 does not innovate before the 2017 OECD Model Convention. This is also a view that is being held by India and Singapore as well. Next slide, please. On the general overview, the general report notes that amongst the jurisdictions who have signed MLI, it is possible to discern them into two distinct groups, the maximalistic versus the minimalistic group. The first one comprising of jurisdictions and where they have listed all the tax treaties, and India falls in that category. The second, which have listed only a fraction of the tax treaty. Now, this on one hand clearly reveals an overwhelming commitment to the BEPS agenda, and an in-principle agreement to MLI is insufficient to address tax leakages in the tax treaties. Now, the overtones of minimalistic versus maximalistic approach on MLI has some interesting trends. The trends in the general report, which have enlisted countries adopting few provisions, which is a minimalistic approach for policy and for bona fide reasons, indicates varying state priorities. The EU report is very interesting, where it raises concern with the EU law, which interacts, overlaps, and even takes precedence over the MLI. In my view, a holistic adoption of MLI reveals that it is not just issues of intent and commitment of the BEPS agenda, but also the design within which the state treaties must find their feet. And hence, MLI shall have to operate within these limitations. A wholesale substitution of the bilateral treaty provision is misplaced and the expectations, in my view, should be moderated. Branch reports of many countries do indicate a minimalistic approach by adopting only those provisions implementing the minimum standards. And in my view, that minimalistic approach is indeed the correct approach. Amongst jurisdictions that took a minimalistic approach, the reasons for their approach have been threefold. Firstly, these jurisdictions generally share the view of jurisdictions that have listed few treaties as cover tax agreements, that treaties are best negotiated bilaterally to minimize complexity and address particular circumstances of the contracting states. Now, I know for that matter, this could dilute the overall impact of the MLI, but I think that is how things are likely to shape up, particularly with treaty partners who have intense bilateral trade and investment. Some jurisdictions take the position that they've already adopted the adequate measures to counteract aggressive tax planning. And India and China is a classic example. So if you look at the new India-China treaty, there doesn't seem to be any reason to look at the additional provisions in the MLI because they have adopted everything that is there in the minimum standard. Next slide, please. India's domestic law amendment and how the MLI is transposed. As I mentioned, it's very clear that the reference is that the PPT test has been transposed over here with no reference to the MLI. The MLI as a document, has been signed just like any other power that is given to sign the double tax treaty. Next slide, please. What is also equally important is the point that I mentioned earlier, that there is no reference. Instead, the exact status of the MLI transposition at least is unknown, and this could be a challenge to the court in the future. In my view, it only enables the government to execute the treaty and sign the MLI, and such objectives could not be optional and are not binding at all. And hence, no larger overall mandate exists to effectuate MLI objectives in the tax treaties. On the overwhelming response of the GAR and SAR, most countries, particularly India, will continue to dominate the domestic law agenda of tax avoidance, where provisions are also familiar to the tax courts as well who have interpreted. And hence, it is likely, at least in the initial years, that the MLI will find immediate acceptability or influence the interpretation of the tax treaty. Next slide, please. On the evidentiary requirement, there is no overt reference in the MLI as a document, nor can a reference be drawn from the text or the explanatory statement that there is any change in the standards of evidentiary proof for addressing tax dispute. And hence the burden of proof, the bona fide test, the substance over form test will continue to determine the correctness of taxpayers' treaty claim. What is also important, and this is more so for India, is the judicial hierarchy and the interpretational approach. Higher and constitutional courts regularly give force to India's treaty obligation. The tax authorities, on the other hand, limit the scope of reference to the text of the applicable law and the tax treaties. The transposition of the larger objectives of the MLI, therefore, will have to wait for indulgence of the higher court. Finally, next slide, please. The taxpayer's perspective. Now, the taxpayers are expected to take a stand that the MLI reflects a position and not the position, in my view. And hence, what is critical is for taxpayers to look at various aspects which will help them protect against the tax authorities invoking the principal purpose test as read along with the MLI. Thank you.
Thank you so much, Mukesh. I think we are clear that there will be a lot of interpretational issues to be part of the tax agenda for the future years along. So I just wanted to now turn to Anna. With all these difficult interpretation issues to be solved, are there any light in the tunnel? Anna, who is a business representative from Belgium, but working in the Netherlands. We all know that business would have liked more, but are we going in the right direction? Please, Anna and Phil, give us your views.
Yeah, thanks, Lieselot. There's no more light here. I'm speaking to you from The Hague, not so far from the IFA headquarters, and the sun has set in the meantime. So I'm very happy to provide some taxpayers' consideration here. I'm doing this against the backdrop of my affiliation with Tax Executives Institute, which serves in-house business tax professionals. So we've been commenting and following up BEPS. And so Philip West will add comments from his vast experience with US business treasury and treaty application. If you look at what taxpayers expect from double tax treaties, they expect it to avoid double taxation and to do so as clearly, as predictably, and as timely as possible. If you look then at what BEPS did, it was talked already, there's 15 action points with only BEPS 14, so 1 out of 15, which was explicitly intended to cater for taxpayers. BEPS 14 did end up in the 4 minimum standards to be implemented post-BEPS, and it's one of the main BEPS action points to be implemented through the treaty network, so relevant for the reconstruction of the treaty network. The other, of course, being BEPS 6, the anti-abuse. Now, most of the changes to the treaty network that have been introduced subsequent to BEPS seem to restrict the scope and application of the double tax treaty for taxpayers. So theoretically, they expand the conditions under which the treaty would no longer be available for taxpayers to avoid or even reduce double taxation. We've gone through a lot of the theoretical assessment on most of these changes, but it's important to consider that the effectiveness of double tax treaties for taxpayers is not just a theoretical issue. It's going to be important to look at its application, and additional concerns have risen about the assessment of whether or not a clause in the treaty will apply in practice. And this is especially of concern with limitation that seem more subjective in application. Now, you can discuss, Carmel made a comment, Johan as well, whether something is objective or subjective. But I think it's got to do with, rather than, if you look at limits to application that outline a factual situation in which a treaty article will apply or not, many of the new limitations are driven by the assessment of taxpayer intentions or purpose of a transaction, like the preamble or the principal purpose test. And to assess whether a treaty will apply will therefore, in increasing number of cases, require jurisprudence before there is a clear view on the application. So even, the objectives or the conditions are not clearly set. We've heard remarks by Daniel Goodman and Johan Hatting, and also concerns raised and elaborated on by Mukesh earlier, that are certainly relevant for a taxpayer point of view and where further work will need to be done. But I specifically want to make a reference to that with regard to timing. Now, the need for jurisprudence to assess whether or not a transaction will meet, for example, the principal purpose test or not, and whether therefore the treaty will apply to a certain structure or transaction, it will be an inconvenience in countries with a fast judicial process. So where one may want to have to wait 1 or 2 years before a definite answer. But there are countries where it takes a decade or more to get definitive jurisprudence. And these kind of periods of uncertainty will be more than an inconvenience, but will likely negatively impact the application of treaties, for example, that include a PPT. Whereas an LOB is admittedly more complicated in its outset, the experience seems to be that once you get acquainted with the mechanics, there is more of an expectation that you can predict with sufficient certainty from a taxpayer point of view to see whether the benefits of the treaty will be limited in your case or not, which is not necessarily the case, for example, for a PPT. If I may turn to Phil in this respect for some additional considerations that would be helpful. So I think we're on slide 64.
Sure, thank you, Anna. Let me say on this discussion about whether it's subjective or objective, it's hard for me to see how a purpose test, the very word purpose implies clearly to me an element of subjectivity. And, there are some areas in the US tax law where a subjective purpose is to be derived through objective criteria showing that subjective purpose. But that doesn't mean that we're not trying to show a subjective purpose, number one. Number two, we don't have any jurisprudence or regulations or guidance on what those objective criteria might mean. And number three, on Anna's point about needing a body of jurisprudence before this is fleshed out, let me point out that the United States has had an economic substance test for almost a century now, with a century of jurisprudence. And I will tell you, it is still unclear. If you think you can point to the line that tells you what economic substance is, I think most tax practitioners would say you are in search of a holy grail yet to be discovered. In fact, when we codified our economic substance test in an attempt to make it more objective, the Joint Tax Committee, the committee that is responsible for commenting, the staff is responsible for writing the ex post legislative history, if you will, to a statute, makes clear that even that test has an objective element and a subjective element. And either Johan or Carmel said that there might be two elements, but there's still a subjective element. And it is that is at the root of why, when I was testifying before the Senate Foreign Relations Committee to try and get our treaties approved 20 years ago, the Senate questioned whether a principal purpose test or a main purpose test in our treaty, proposed treaty with Italy and our proposed treaty with Slovenia should be approved or reserved. And they ultimately determined it should be reserved because there's too much subjectivity. So now I know Anna identifies as Belgian, but she's sitting in the Netherlands now. So we have some history. Our first limitation on benefits treaty was in the US Netherlands treaty negotiated decades ago. That provision seems as complex as it is, less subjective. It seems indisputable to me, at least. Back to you, Anna.
Okay, thank you. So basically, this you can tell, in the next slide, there's a this kind of discrepancy leads us to basically a second big point for taxpayers, which is the expected need for improvement of dispute resolution. Because basically, when disputes cannot be resolved, and interpretations differ, and we've heard a lot of examples of where they can be different in different countries, the lack of consensus between countries on how to allocate taxing powers and how to interpret and how to apply the treaty will turn into a problem, or will turn a problem between countries into a problem for taxpayers, because it will generate double taxation. In her introduction, Carmel Peters already elaborated on the improvements under BEPS 14, but overall it consists of 21 elements, 12 best practices for jurisdictions to improve their legal and administrative framework on key areas like dispute preventions, availability and access to MAP, resolution and implementation of MAP agreements. Now, all these areas are very relevant for taxpayers. And indeed, the expectations of taxpayers for dispute resolutions that were very clearly voiced also, in view of BEPS, when BEPS 14 was being brought up, was that there needs to be an improved access to cross-border dispute resolution, and which actually would mean having an instrument that results in an actual resolution within a predictable time frame and yielding a result that is predictable. So within a range of expected outcomes. For all parties concerned, a MAP procedure requires a significant investment in time and effort. And without an indication of how long you expect a MAP to take, or without a foreseeable range of possible outcomes, the discussions that you will have with tax and finance leadership in a company to decide whether or not to embark on such an effort will be strenuous. And so in one way, it limits the access to cross-border dispute resolution because there will be a reticence to actually embark on it. Now, the MLI improvements have yielded best practices. They all go in, a lot of them go in the right direction. But they remain best practices with no consequences to non-compliance. There's peer reviews that have been foreseen and they have been running. And as Phil said earlier on other things, the OECD website has a lot of information on this. Over 69 jurisdictions have already been subject to review, 1,500 recommendations with reports transparently posted and all contributing very much to improvement. But in the end, this improvement will result to a best efforts obligation. There's nothing firm. There's nothing in the sense of a performance obligation for the parties involved that would ensure actual resolution. With further analysis of the peer review expected to be published by the OECD on Wednesday, the OECD progress reports through July 2020 indicates that improvements in speed have been made, resources have been made available, and there's more comprehensive guidelines. But despite these efforts, there are still more cases received than cases resolved, and not all cases that should go to MAP actually do. And these are concerns that resonate with the feedback from a taxpayer point of view. So improvements in the field are experienced anecdotal at best, and there's not a lot of improved enthusiasms about MAPs because a lot of people still don't know how long they will take in a lot of countries. Whether they will actually lead to resolution is still unclear. And if so, it's unclear, what kind of resolution will be gotten. In that respect, the only instrument that's currently available that actually resolves cross-border disputes is still mandatory binding arbitration. As you can see on the next slide, the MLI includes an optional clause on mandatory binding arbitration, and around 30 countries have selected to include them through the MLI. Now, a mandatory binding arbitration actually obliges the party to submit unresolved issues to an independent arbitration panel, which will ensure eventual resolution of the case. Now, whereas further improvements to MAP could improve further the timing of the process and maybe even the transparency of the process, so potentially by involving taxpayers, it's less evident on how further MAP improvements could ensure resolution or could avoid non-tax technical pressures on the eventual result that could give rise to unexpected settlement or arrangements. Mandatory binding arbitration would be expected to take out such pressures by including an independent decision makers. Now, we heard earlier from Michael Leonard about a skepticism from mandatory binding arbitration in developing countries, whereas you would expect that the setup of an independent decision maker that's included under mandatory binding arbitration would actually reduce these pressures that could come from more political or economic discrepancies as compared to MAP. The Netherlands, for example, has included arbitration in its treaty policy going forward. The US is also such a country, Phil. So if you want to share some views on that, you might be on mute.
Yes. Yep. So look, as Anna said, there are two minimum standards. We talked about one, treaty abuse, and the other is MAP. And I agree with Anna that when we think about reconstructing the treaty network, resolving disputes more efficiently and more effectively, when you count the number of things that the taxpayer community has gotten out of the entire BEPS exercise, resolution of disputes more efficiently and effectively is, the biggest one, I think, which, sort of tells you something. We have 15 action items and we have one on more efficient and effective resolution. As a practitioner who handles these kinds of cases, I can tell you one of the biggest frustrations is the amount of time it takes to resolve the cases and the unwillingness of some competent authorities to reach what, I believe are reasonable conclusions. Now, I guess we're all biased to some extent, but we've had enough experience to justify some frustration there. Let me just make two very brief comments here. First, the US model treaty contemplates mandatory binding arbitration in our bilateral treaties. Now, having said that, we only have binding arbitration in about a dozen treaties currently, and it's mandatory in most, but not all of those. So having said that, if one way to more effectively get what taxpayers seem to have gotten out of the BEPS project is more efficient and effective dispute resolution, and the best we can come up with right now, for reasons Anna articulated, is mandatory binding arbitration to force reasonable resolutions. And by the way, in the US, the model treaty system of arbitration is quite detailed, and it contemplates what we call baseball arbitration, where you pick one side or the other. There's no slicing the baby in half. We pick one or we pick the other, and that forces the parties to be reasonable in what they propose. And again, I go back to Michael Leonard's question about skepticism of this. I think that's worth more discussion because to me, when we talk about reconstructing the treaty network from the perspective of the taxpayer, one of the things that is most enthusiastically embraced is mandatory binding arbitration. And from my perspective, the baseball type arbitration is a good way to proceed as well. Anna?
Yeah, that moves us to the last slide of our piece, Lieselot. So as this extensive panel has been proof of the fact that many issues still exist as to how to apply treaties post-MLI. And in addition to studies like the ones included in the cahier and in this presentation and later by Johan, actually jurisprudence will be needed to assess whether or not a treaty provision will apply in the first place. So increased uncertainty will have to be managed by all concerns in the meantime, and in which the effectiveness of local judicial activity should not be forgotten. As to dispute resolution, what has been done under BEPS 14 is an improvement, but further improvements will be needed, like commitments to deal with issues faster, which would not only settle uncertainties for taxpayers, but also for tax authorities as to revenues generated. Commitments to improve resources, improve transparency, taxpayer access to procedures, and actual application of these commitments. And getting more countries comfortable to accept mandatory binding arbitration will remain a relevant point, as in view of actual resolution, mandatory binding arbitration remains the only game in town. However, what could be considered is to reduce the pressure on mandatory binding arbitration if more cases could be resolved earlier, so that mandatory binding arbitration would become more of an instrument of last resort, because you do need something that actually resolves your disputes. And this could be done by improving dispute prevention. Dispute prevention is something that has a lot of interest from taxpayers, and further developments can be done both unilaterally, bilaterally, but also multilaterally, like, for example, considering ICAP. From a taxpayer's point of view, dispute prevention has been generating a lot of uptake as well, not just with formal instruments like ICAP, etc., but also to make use of offered ways of working with tax authorities, either unilaterally and bilaterally, such as cooperative compliance approaches that have been set up in the Netherlands, in the UK, CAP in the US. But there's also interesting approaches in other countries, like, for example, the use of an ombudsman in Mexico, all to avoid disputes and basically to limit the further escalation of the problem. Now, making dispute prevention more acceptable would also be a good subject of further IFA work, and hopefully not something that would be as tiring for Johan, but I think it would be something that would help a lot moving forward. Back to you, Lieselot.
Thank you so much, Anna and Phil. I think you made your points very clearly. on the difficulties faced. And I pick up the point, Anna, is the dispute prevention. I think that is a very good indicator of what can be done, and we could move in that direction as well. Hopefully not in one only direction, in many directions, to try and solve what you sort of and Phil have clearly pointed out are things that we need to address. We are now coming to our final session, and here we should try to have a broader look on the treaty network and what changes outside the context of the MLI. What is really going on? So Johan, please take us through some of the recent research to shed some light on the actual reality. Please, Johan, go ahead.
Thanks very much, Liselott. Well done to all the participants. I see we're about half down from where we started. You're all the diehards, so you've remained for one of the most exciting parts of the presentation. So, as Liselott said, we tried to also reflect on many views expressed today of where the treaty network ought to go, where did it go in the reconstruction process, but what is actually happening now on the ground post the finalization of the BEPS project. Are more or less tax treaties signed? What type of country is entering into a treaty today? OECD, non-OECD, high, middle, low-income countries. And what is the implication of what's going on today for the reconstruction project? By whom is it being reconstructed? And here I don't mean the G20 and the OECD, but are there other players that we should take note of, and what might be their purpose and strategic objective? So next slide, please. So we performed some initial research, and I must thank the IBFD and Professor Scott Wilkie and Corey LeBlanc, who gave me valuable assistance. Of course, the views expressed here are mine alone. What you see on the slide, ladies and gents, is the rate at which the treaty network has expanded after the Second World War. And we see the bulge in the graph is really around the end of the Cold War, the globalization age, where the rate of expansion was highest. So between 1990 and 2010, on average, there was about 111 tax treaties concluded per year. Now, since the global financial crisis of 2008, there's been a sharp decrease in the rate at which the network is expanded. On average, in the last 10 years, 80 treaties are concluded. So it's a decrease of about 30% in the rate of the expansion per year. So what we have done is try to look at the last 5 years against this broad background of a decrease in the rate at which the treaty network is expanding. So next slide, please. So on this slide, you see here the treaties concluded in the last 5 years, viewed from through two lenses. So firstly, whether these treaties were concluded by OECD countries or not. That's on the right-hand side. And you'll see that 53% of all treaties, is about 400 of them, were concluded between non-OECD countries. About 39% of them were OECD to non-OECD, and between OECD countries, only 8% of this network of treaties. On the left-hand side is a different lens, taking the same set of treaties and classifying countries according to whether they're high, middle, or low income on the World Bank Index. Now, what you see is almost an apparent contradiction, because 52% of treaties are concluded between high and middle income countries. So how do you marry these two graphs up? The only explanation for this is that it's non-OECD high-income countries who are most actively expanding their treaty network the last 5 years against the backdrop of an overall trend of a decrease in the expansion of the treaty network. Next slide, please. So we did further work by looking more closely at the high-income countries. And what you will see on the slide on the left-hand side is essentially 4 high-income countries who are not OECD members, who've been responsible for the most expansion of the treaty network with middle-income countries. One country has been responsible for 11% of all treaties concluded the last 5 years. On the right-hand side, you see those middle and low-income countries which were most active in expanding their treaty networks, and most of them are in Africa, in fact. So we'll get back later to this dynamic which is happening in the current treaty network, and I'll reflect a bit on this relationship between high and low income countries. Next slide, please. But first, we also wanted to get a sense about which models are prevailing in the last 5 years. And so we tested this by just looking at two of the key elements of the UN model. The first one is the so-called service PE clause. And what we found is that it's in 52% of the treaties concluded in the last 5 years, you find a service PE clause. Now that roughly aligns with the fact that 53% of the overall treaties the last 5 years were between non-OECD countries. But of course, the OECD model acknowledges the services PE. And so you see that out of the treaties with a service PE, 22% of them are between OECD and non-OECD countries. So there seems to be some acceptation amongst OECD countries even of the service PE clause. Next slide, please. The other key element of the UN model, of course, is the clause on technical service fees, Article 12, capital A, introduced in 2017. And here the picture is one where this clause has not been largely taken up in the last 3 years, only in 11% of treaties. Next slide, please. But if you look at treaties the last 5 years where both the service PE and technical service fee clause has been included, you see that the change in the model position, the UN model position in 2017 did have some impact. There's an upward shift in gears if you look at how many treaties contain both clauses from 2017 onwards. I should say 2020 we should probably not take seriously because the data is not in for the whole year, and of course COVID has had a negative impact on treaty negotiations. Next slide, please. Then, as I mentioned earlier, I had a closer look at this relationship between high-income countries and low-income countries where a lot of treaties have been concluded. Now, firstly, if we look at the cohort of, firstly, why is it important to look at this relationship? You can expect, I think it's a reasonable assumption that when a high-income country negotiates a treaty with a low-income country, the asymmetry in negotiating capacity and power is at the extremes. So when you read these treaties, you can almost be certain that it reveals the policy and the strategic objective of the more powerful partner to the relationship. And so it tells us much about almost voluntary acceptance of BEPS measures in treaties. But what I did here is also look closely at the source taxing rights that high-income countries give to low-income countries. So some observations here. When it's OECD high-income countries concluding these treaties, there's a positive outlook on source taxing rights. Many treaties do not reduce the source rates beyond the domestic rate, but they are less consistent in including BEPS features. So some of them voluntarily included BEPS features where were not covered by the MLI. More than half were not covered by the MLI. It seems that OECD countries, when they approach low-income countries, at least accept that they need to, for some of them, guard them against abuse. But the picture is very different when we look at the other cohort of high-income countries, and that's the next slide. So here, ladies and gents, there are some surprising results, for me at least. Firstly, when non-OECD high-income countries conclude treaties with low-income countries, the prospect for source taxing rights is dismal. to put it bluntly. I've seen clauses in these treaties which I did not think possible. For example, allowing zero source taxing rights over gains from immovable property, or a substantial reduction of source taxing rights, for example, and that these are with resource-rich countries. So secondly, almost none of these treaties contain any BEPS features. They're generally not affected by the MLI. What is apparent is that there seems to be something going on with investment objectives here, because if there's a correspondence in a lot of these cases between the year in which a bilateral investment treaty is signed with these countries and when a tax treaty is signed. So what is the implication of all of this data for our discussion here today? For some of these countries, double taxation is objectively impossible because they don't have an income tax, which means that these treaties are unconcerned with the avoidance of double tax. They're not concluded to protect the tax base. In some cases, the tax base is wholly emasculated, which means they're concluded for other purposes. So it reveals that what we all know for a long time already is that tax treaties are concluded for a mixture of purposes, for political purposes, for foreign policy objectives, in the hope that foreign investment will be stimulated. And so this aspect of the treaty network is continuing. I think it's very clear that some countries are concluding treaties for non-tax objectives. Investment stands out here. One closing thought here is that if Pillar 2 is widely adopted, the benefits from this type of treaty and emerging treaty hub may be neutralized. So thanks very much, Liselott, back to you.
Thank you so much, Johan. Some very interesting results and a lot of interesting data that have given us really a lot of thought to think about and being concerned about, I think. The result that 52% of all treaties signed in the last 5 years has used the typical service PE means that the UN model obviously has a large impact as well. So it's sort of conflicting messages here, and they're very interesting because I think you're right. You can't just see one side of it. It's different factors, and it's different things going on. So finally, we thought we should give the word to Phil, if he could sort of share some views on why the US has relatively few treaties. Please, Phil.
Well, I hope I don't feed into any stereotypes here by the United States having the last word, but let me just observe, following on Johan's comments about purposes for entering into treaties. I think the US has been pretty successful, and my experience in the Treasury Department has been pretty successful in trying to enter into treaties only where justified on the merits. And the Treasury has used 3 tests, really, that there is actual double taxation to be relieved, that there is sufficient business interest, ideally on both sides, and there are sufficient capital flows between the US and the prospective treaty partners. And I, in our prior discussions, pointed out in different contexts how limited resources really affect a lot of this discussion, whether it's enforcement or treaty negotiation. And it's certainly a factor in deciding how to allocate precious resources when we have a Senate, for example, that doesn't move treaties for years because of one senator's objections. That colors the Treasury Department's view of the extent to which it should be devoting resources. Also, committing a lot of resources to the OECD work on BEPS generally, Pillar 1 and Pillar 2 more specifically. There are only so many hours in the day. So that's really the only observation I had from the US perspective. There's occasional political pressure, but I think in general, the US Treasury is has a lot of clout in the cabinet and is able to stick to the merits for deciding when to negotiate treaties.
Thank you, Phil. And I think your comments have illustrated very well some of the for many other countries to consider. So thank you for that, Phil. Now we are moving quickly because we're a little bit late. So we're going to go to our voting. Let me see here how I can do this. I'm supposed to invite you all to do votes, and I will click where I have the questions. Oops. Here we go, please. So, do you all see the question now? Question 1 is, which is preferable, PPT or LOB? So please go ahead and vote. Uh-oh, PPT is taking in.
I think we have to wait for the mail-in ballots.
You were waiting to make that comment, David, weren't you? You had that preloaded.
So shall we wait a little bit more? There doesn't seem to be many more people coming in. We're 49:51 here.
I can't see the results.
I think we have to wait for the mail-in ballot.
Can others see results? Because I cannot.
Yes, the results is up on my screen, and I have now 48 in favor of the PPT, and 50, it went down, 47, and now I have a preference for LOB. 50, well, it's fluctuating, 51, 52. It's very close. So, interesting. I think...
Congratulations, Phil.
Yes. Well, I think you pointed out, Mukesh, that Chile has quite a lot of LOBs in their treaties as well. So I'm
election monitors. Lisa, do you have adequate vote monitors watching you count the votes?
I rely on the IFA platform here.
You can do a recount and share the final results at the end of the conference.
I'm going to see if I can say there. Am I now? Do you all see the results now? Okay, great. Let me just go to the next question then and see how I can do that. Oops. I'm supposed to have a, okay, relanzar, continuar, and then, oops. Here we are. Here is the second question. Do we expect the map changes in the MLI to make the map process materially more efficient and effective? Please go ahead and vote. Oh, this is very tight too. Now it's 50-50.
Lisa, are people voting more than once?
No, I don't think so. I don't think they can do that. No, because we have a total of 178 voters against 272 who can vote. We have 89 for the MLI to make the map process materially more efficient and effective. So there you are, Anna.
Yeah. I think Carmel is concerned that the elections are rigged.
Yes. So let's go to the last question. I'll see how I can do that. It's incredible. Yeah, it's very close to the poll here. Oops, I want to find the last question. Has the MLI proven that multilateral tax treaties are useful or practical so that more multilateral treaties should be a priority? Please go ahead, yes or no? Ooh, ooh. Seems to be a little bit clearer here that people are not that keen on the multilateral treaties. I think we have been a little bit negative today. We have sort of pointed out quite a lot of the difficulties, of course, and apparently people are skeptical, as well as our panel, actually. So I suppose that is also a sign. So that's the final result here. Here we had a little bit more of margin. We had 54% voting no and 46% yes. So I think that we have had close votes. Yes, always a hung parliament here. So thank you very much from our audience for picking up our questions. Thank you to this fantastic panel. Hopefully the hard work has been worth it for the audience. Thank you, IFA. Thank you, PSC, Robert and Scott for keeping us going. A special greeting and a warm virtual hug to my friends in IFA Latam, IFA Mexico. I was very much looking forward to catch up with you all in Cancun, but I hope it will be another time, as they say. Now I am going to drink a margarita and I'm going to eat chicken with mole sauce. Thank you all, and thank you, well done, everyone. I've really enjoyed it. I hope we managed to transmit to the audience the discussions that we've had in this panel, which has been a great honor for me to serve and to transmit today. So
let me say thank you to Liselott on behalf of the panelists. Liselott, you did a wonderful job, and we really appreciate your leadership here.
Thank you so much. Thank you so much. I'm actually going to try to put my video on and see how my connection is working for a while. Apparently it holds up a little bit. So thank you so much to all of you, and looking forward to see you another time. Thank you.
Bye-bye.
Enjoyed it. Take care.
Thank you all. Bye.
Bye. Thanks, everyone.
Bye-bye.
Yes.
Thank you, Hans. Bye-bye.
No. Thank you very much for your kind words. And I think that I may try and have a beer at home, because the pubs are closed due to Corona. So I can't take anything like a margarita or whatever here. So we'll find a way out. Anyway, I would like to thank all the participants, those who attended, especially the excellent panel that has keeping us interested the whole afternoon on this subject. Thank you, panelists. Thank you, Liselott Kana. It was a great debate, and it was very much worthwhile. I would like to ask the attention of the attendees to the poster session that will start in a few seconds. And tomorrow you can visit the poster session at 2:30 p.m. And later on at 3 p.m. until 3 p.m. And then you can join the virtual meeting on subject 2 in the virtual meeting room that is just not yet open now. For now, I wish you all a pleasant rest of the day, whatever it may be, until tomorrow at the IFA virtual event.